sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Okay. Hey, good afternoon, everyone. Judge Egan, I'll be taking care of the initial appearances this afternoon. We'll bring you up to the podium one at a time. Take a look at the reason you were picked up. Talk about a bond if you're eligible for bond. We'll set bond as well as other conditions of release, okay? Let's see who we have here today. Who's with the PD's office out at the jail?
I'm John Mancini on behalf of the Public Defender's Office, Your Honor.
This is Mr. Mancini?
Yes, Your Honor.
Good afternoon, and who's here for the state?
Charles Fink for the state, Your Honor.
Last name is Fink.
Fink.
Ms. Moreno's here again with pretrial services. Do we have Spanish? Do we have? Okay. Mr. Mancini, do you know if you have any need for a Spanish interpreter?
Yes, Your Honor. I've identified 3 individuals who have requested a Spanish interpreter, and I do have a request from corrections to have somebody go first. He's also one of the Spanish interpreter matters.
Okay, then why don't we take care of those first? What are the names?
The gentleman we wish to have go first today, Your Honor, is Mr. Giovanni Acevedo Gonzalez. And then the other 2 Spanish interpreter matters are Jordan Lazu Soto and Mr. Hector Naboa Harand.
All right, give me a second to locate those. Acevedo Gonzalez,
Acevedo Gonzalez, I got Jordan Lazuzoro. And I think the last one was Hector Naboa. I have something for you for that case. I don't receive. That's on Naboa. No.
Okay, so Mr. Acevedo Gonzalez can come up to the podium.
He is present and approaching, Your Honor.
Thank you.
Good afternoon, Your Honor. Jaime Sotomayor, certified federal interpreter, already sworn.
Thank you. Good afternoon. I think we have 3 matters for you today. The first one is 2022 MM1147. He's at the podium, and can you please ask him if his name is Giovanni Acevedo Gonzalez?
Buenas tardes. ¿Usted es el señor Giovanni Acevedo González? Yes.
I have reviewed the police report. I do find probable cause for 1 count of domestic violence. I'm sorry, 1 count of petty theft. Go ahead.
Muy bien. Luego de leer el informe policíaco, lo estoy encontrando causa probable para un cargo de hurto menor.
We can set bond in the amount of $500. Order he have no return to the neighborhood Walmart on West Vine Street.
Voy a poner una fianza de $500 y no puede regresar al neighborhood Walmart de West Vine.
And we can appoint the Office of the Public Defender to represent Mr. Acevedo Gonzalez.
Y vamos a nombrar a la oficina del defensor público para que represente al señor Acevedo González.
Your Honor, for the record, the charge does qualify for direct PTR.
Y el cargo cualifica para ser liberado directamente con condiciones de la oficina de derecho al juicio.
And that's fine, I noted that. He can do pretrial release rather than post the bond, so.
Muy bien, entonces lo podemos liberar con las condiciones de la Oficina de Libertad anterior a juicio en vez de pagar fianza.
And that would include the condition of no return to that Walmart.
Y eso incluye la condición de no regresar al Walmart.
Okay, thank you, sir.
Thank you very much.
Okay, and then the next case is a Jordan Orlando Lazu Soto.
He is approaching, Your Honor.
Mr. Interpreter, it's 2021 CF 2179.
2179.
And if you could ask him if he's Mr. Lazu Soto, please.
¿Usted es el señor Lazus Soto? Yes.
Okay, so he is on probation, and Judge Karsten issued a warrant for violating probation.
Muy bien, usted se encontraba bajo libertad supervisada o probatoria y el juez Karsten emitió una orden de arresto por una violación de esa libertad supervisada.
He's being held no bond on that, and we can appoint the Office of the Public Defender.
Va a ser detenido sin fianza, pendiente de esa orden, y estamos nombrando al defensor público para que lo represente.
Okay, thank you, sir.
Muchas gracias, eso es todo.
All right, and then we have Hector Naboa Harand, and Mr. Interpreter, that's 2022 MM1142.
Hector Naboa.
Your Honor, if I may.
Yes, sir.
I was provided some information. I believe you may have been provided the same information. So I do have a PC argument on this case.
Muy bien, se me sometió una información y me parece que usted ha recibido esa información, así que yo tengo un argumento que hacer aquí en cuanto a causa probable.
Okay, well, he came in on an arrest warrant, so
Bueno,
probable
está aquí por una
cause,
orden, está aquí por una orden de arresto, así que ya ha habido causa probable.
probable cause was previously found.
Yes, Your Honor. I believe that the court may not have had this information in front of them when they made that determination.
Sí, su señoría, pero me parece que el tribunal quizás no tuvo esta información frente a ustedes antes de que se hiciera esa determinación.
And has the state seen what he's talking about?
I don't believe so, Your Honor.
Okay, do we have an?
I can print a copy.
We'll print it. Give me a minute. I'll read this. This is a supplemental apparently that I didn't have until I walked in here.
Yes, Your Honor. It was not provided to me until I arrived at the jail as well.
Permítame un momento, voy a imprimirlo porque esto fue un suplemento que no se me había suministrado anteriormente.
So we'll print it out, give a copy to the state, and let me take a look at it now.
Lo vamos a imprimir, le vamos a dar copia a los fiscales y permítame revisarlo.
See if I can log into the printer. Oh. One sec, let's see. It's not letting it print, Josh. For some reason.
Just that narrative page is probably going to be good enough. Thank you. Fink, have you had a chance to look at this?
Just one moment, Your Honor, I'm conferring.
Permítame un momento, señoría, estoy consultando.
I believe that there shouldn't be PC arguments on warrant cases. I don't even have the original facts of the case. At worst, state would just ask for a reset to look into it.
Me parece que no debería haber argumentos en cuanto a causa probable en caso de que hay una, pero como mucho pediríamos entonces que se posponga esta toma de cargos hasta que podamos consultar.
Mr. Mancini, did you hear that?
Yes, Your Honor, may I respond?
Yes, sir.
While it is not normal practice to have PC arguments, especially on a warrant case, I believe in this case, because this information was likely not in front of the judge that issued the warrant, I would request that we be allowed to discuss it, bring it forward, and it does show very concretely, it's a statement by a police officer that they have concrete evidence that my client was in a different...
Hold on, you have an interpreter. Hold on.
Oh, sorry.
Sí, aunque no es usual que tengamos un argumento de causa probable en un caso donde ya hay una orden de arresto, nos parece que el juez no tenía esta información al momento de emitir la causa probable y entonces tenemos el caso de que en este caso la declaración viene directamente de un policía que indica que tenían evidencia de... Please continue.
So it's concrete evidence that shows my client was in another state, and that shows that the alleged violation by the AV likely did not occur. So we would request to have him ROR as to this case, Your Honor.
El policía indica que tienen evidencia de que mi cliente se encontraba en otro estado al momento de este delito y por lo tanto es muy probable que no haya ocurrido el alegado delito. Así que vamos a pedir que por favor se le niegue la causa probable en este caso.
Well, the information available to Judge Nunez Navarro did provide probable cause, okay? So there was probable cause for his arrest.
Bueno, la información que tenía el Núñez Navarro al momento era suficiente para encontrar causa probable, así que por lo tanto se emitió la causa probable en este caso.
The supplemental information provided does have evidence that might suggest he didn't do it.
La información suplementaria que se ha suministrado provee cierta evidencia de que es probable de que él no haya cometido el delito.
But I don't know if that's a basis to undo the probable cause finding or necessarily to release on ROR.
Pero a mí no me consta que eso sea suficiente para invalidar la determinación de causa probable o como mínimo darle libertad bajo su propio reconocimiento.
But we can ask the state what its position is regarding the request for a release on its own recognizance.
Pero vamos a preguntarle a la fiscalía cuál es la posición de en cuanto a liberar al confinado bajo su propio reconocimiento.
Yes, the state would request a reset, 24-hour to look into it, and if the state has the evidence itself, the state may take action to dismiss before that.
Muy bien, pues entonces la Fiscalía tiene la posición de pedir una posposición de 24 horas para examinar el asunto y si el Estado tiene la evidencia de que es probable que él no haya cometido el delito, entonces el Estado procedería a eliminar los cargos.
And Mr. Mancini, I don't want to create work for the weekend judge, but that might be the best thing to do because he is out on bond and I was going to have that bond forfeited, so maybe 24 hours might help clear things up.
Yo no me gusta crearle trabajo extra a los jueces que están trabajando los fines de semana, pero yo creo que sería lo más sabio y lo más prudente hacerlo de esta forma y no conceder una fianza que luego pudiera ser revocada.
Yes, Your Honor. For the record, defense would reiterate its request for ROR, but we will defer to the court in this matter and understand that that option is valid as well.
Muy bien, pues para propósito del acta vamos a reactivar nuestra petición de que sea bajo propio conocimiento, pero entendemos que el tribunal tiene la alternativa y la opción de hacer lo que se está pidiendo.
I mean, was Mr. Naboa Harand, was he arrested in Georgia or Florida?
El señor Novoa fue arrestado en Georgia o en Florida.
Well, he may not, don't ask him that. There's other questions here. He says he was in Georgia, but I'd like to know where he was arrested and what his travel arrangements were in the state. Can have 24 hours to look into that. Okay?
Pero no le pregunte eso. Aquí hay información. Lo que necesitábamos saber era si fue arrestado en Georgia o en Florida, y entonces tenemos 24 horas para poder indagar el resto de la información.
So it'll be reset tomorrow, and tomorrow is what, Saturday, so that'll be tomorrow morning with the weekend duty judge, okay?
Así que lo vamos a posponer hasta mañana, y entonces se va a atender mañana por la mañana con el juez que va a atender el trabajo del fin de semana.
Thank you.
Thank you, Your Honor.
Mr. Interpreter, thanks for your help.
You're welcome, Your Honor. Have a good day. I'm sorry, Your Honor. I don't have your name and I can't see you from where I am.
I'm Judge Egan, Robert Egan.
Egan. Okay, perfect, Your Honor. Have a good day.
Thanks, bye-bye. Okay, how about Sean Lufkin? If he's here, come up to the podium, please.
Your Honor, I would be requesting a 24-hour reset on Mr. Lufkin. He is apparently detoxing and was not able to be brought to the chapel today.
That's fine. We can reset him for tomorrow.
Thank you, Your Honor.
How about, is it Christopher Ray Risitelli?
He is present and approaching, Your Honor.
Good afternoon. Are you Mr. Risitelli?
Yes, sir.
Hi, Mr. Risitelli. It looks like Judge Karsten issued a warrant for missing court on 2 counts. He did set your bond in the amount of $1,500 as to count 1, $500 on count 2, and this is 2022 CF 102. We can appoint the Office of the Public Defender to represent you, okay? Thank you, sir. All right, how about Calvester Smith?
He is present and approaching, Your Honor. While not a PC argument, this client has requested that I bring some information forward to the court.
Okay. Are you Mr. Smith?
Yes, sir.
All right, Mr. Smith. He does have 2 cases. Let's identify those first. 21 CF 796, brought in on a petty theft. In 21 CF 1609 was failure to appear. Which case did you want to talk about?
Your Honor, Mr. Smith had a discussion with me about the failure to appear. When this was issued, he believes he was already in custody in the Orange County Jail, and as such, it was not a willful failure to appear, Your Honor.
And this was on what date? June 25th. Is there any easy way to figure out whether he was in Orange County Jail on June 25th? I don't have my computer in front of me. Are we able to verify that? Because if not,
Yes, Your Honor, I did not have access to a computer as well. I was not able to verify it. He just requested I bring it to the court's attention.
well, take a look into that. I'm not in a position without verification to do anything about that, but he can get a bond hearing within 72 hours. I think would be the appropriate thing to do. But the first case, the 21 CF 796, probable causes found for a petty theft with 2 priors or subsequent offense. We can set his bond the amount of $1,500. Order he have no return to the Walmart on Old Lake Wilson Road. We can appoint the Office of the Public Defender. And as mentioned in the other case, Judge Nix Walker did issue a no bond warrant for failing to appear. We can appoint the PD there as well, and they can look into whether he was in the county jail or not at the time, okay?
Yes, Your Honor.
Thank you, Mr. Smith. Good luck, okay? Is Dustin Edward Williams?
Present and approaching, Your Honor.
Are you Mr. Williams?
Yes, sir.
Hi, Mr. Williams. Looks like you are on probation as well. Judge Karsten signed a warrant for violating probation. Right now, it is no bond. It looks like allegation is a new law violation, I think, in Polk County. But right now, it's no bond. We can appoint the Office of Public Defender to represent you, okay?
Yes, sir.
All right, thanks, sir. Yes, sir.
He does have a pending dependency case that he has to go to very soon. Would Your Honor consider setting a bond?
Not with a condition 5 on someone else's warrant. It's not that I don't care, but it's just not the right thing to do typically, so, okay.
Yes, Your Honor.
Thank you. All right, how about Melissa Alexander?
President approaching, Your Honor.
Are you Miss Alexander?
Yes, sir.
Okay, reviewed the police report. I would find probable cause for 1 count of robbery, and 1 count of domestic violence battery. They live together, do we know, Mr. Mancini?
I do not believe so, but may I reconfirm, Your Honor?
Sure.
Your Honor, they do not live together.
Okay, all right. This could have been mutual. There's a lot going on here. I'm not going to give her a typical bond as I would for robbery.
Yes, Your Honor.
I'd set it for $1,500 now as to count 1, 500 count 2. We would order no contact as a condition of release with the victim alleged. They would have to maintain separate residences, of course. And if she has firearms, those need to be surrendered to law enforcement within 24 hours.
Yes, Your Honor.
Okay, and we can appoint the PD, all right? All right, thank you, good luck. How about Ronnie Flowers?
President approaching, Your Honor.
Thank you. Okay, are you Miss Flowers?
Yes.
Okay, Ms. Flowers, I've reviewed the police report. We do find probable cause for 1 count of domestic violence battery. I believe you live in Georgia, don't you?
I sure do.
Here on vacation?
Yes, for my daughter's birthday.
It's supposed to be the happiest place on earth, Disney. When were you planning to go back?
Sunday, but since this happened, tomorrow, I guess.
And it looks like pretrial reached out to, are you married?
No,
No, to the other person involved here,
my baby father.
father of your daughter, right? Okay. And wasn't able to,
No.
no contact? Do you know, is your daughter with him?
Yes, she is.
All right. Do you live together in Georgia?
No, you don't.
No? I'll set your bond amount of $500. I do have to order no contact with the alleged victim at this time. You have to maintain separate residences. Have you heard about your daughter? Has she contacted you, or has anyone contacted you?
No.
Okay. Mr. Mancini, why don't you chat with, I mean, look, I do want no contact with the other person involved, but if there's a way we could get her to be able to speak with her daughter, that's fine. I don't know if there's a intermediary, a grandparent or aunt or uncle who could help us.
Yes, Your Honor, just give me 1 moment.
Sure.
Your Honor, she's informed me there is a third party that both the father of her daughter and her trust, it would be her mother, Ms. Anisha Flowers, and she's willing to do third-party contact about the child through her.
That's good. So we can allow that, Ms. Flowers' mother, to do that. So when you get out, Ms. Flowers, you can, any contact with your daughter's father would be through your mom, and then you can pick up the daughter, whatever you guys think is fine. But no contact with him until this matter's been resolved one way or another, okay?
Okay.
All right, and we can appoint the PD here. Anything else? Good? All right. Thank you. Good luck, ma'am. How about Heather Hamilton?
President approaching, Your Honor.
22 MM1149. All right, are you Miss Hamilton? All right, Miss Hamilton, I do find probable cause for 1 count of domestic violence battery. I believe this involved your brother Joshua. Mr. Mancini, do they live together?
Let me reconfirm, Your Honor. Yes, they do still currently live together, Your Honor.
So we haven't had contact with the brother, but I'll set bond the amount of $1,000 plus pretrial release. The conditions of pretrial release is I'd like to, in addition to any standard conditions, I'd like to have her drug tested, please. And then she's to have no contact with her brother, Joshua, while this is pending. They do need to maintain separate residences, so if he's still living there, she'll have to make arrangements to live elsewhere. She can return one time, accompanied by law enforcement if she needs to get any of her belongings. She's not to possess any weapons or firearms as a condition of release. If she does have any firearms, those will be surrendered to law enforcement within 24 hours of her release.
Yes, Your Honor.
And if I didn't mention it, we'll appoint the PD to represent her, okay?
Yes, Your Honor, thank you.
Thank you, Ms. Hamilton.
Say random drug testing?
I want her drug tested.
Would it be weekly or randomly?
Well, drug tested first to see what she's on, and then I would like it to be weekly after that while this is pending, okay? But if she tests positive the first time, that's not going to be the basis for a violation. I just want to see if she's on anything, and then we'll go weekly, okay?
But you didn't order, do not consume any.
Well, we're ordering that too. She's not to do, take any drugs that are not prescribed to her also as a condition of non-prescription medication, okay? All right, how about David Heap?
Your Honor, I believe Mr. David Heap has bonded.
Okay, thank you. Gary McWhite.
President approaching, I do, defense would have a probable cause argument as to one of the charges alleged.
All right, are you Mr. McWhite?
Yes.
All right, two cases. You got 22 CF 1470, 22 CF 1472. Mr. Mancini, what case do you want to talk about?
The case that involves the resisting officer with violence charge, Your Honor, I do not have a case number in front of me. I apologize.
That's 22 CF 1470, I believe. Are you just arguing the with violence part?
Yes, Your Honor.
Does the state have any objection to reducing it to without violence?
No, actually, I had that notated myself.
Okay, all right. So, yeah, we'll accept the argument. But as to that case, any others, Mr. Mancini?
No, that was my argument, Your Honor.
All right, so on that case, 22 CF 1470, probable cause for one count of domestic violence, a battery, and we'd set bond there in the amount of $1,500. One count of resisting an officer without violence, count two, and that would be a bond in the amount of $500. Count three, criminal mischief, damage greater than 200, less than 1,000. That could be a $100 bond there. We would order no contact with the victim alleged. They do need to maintain separate residences. Mr. McWhite's not to consume any alcohol as a condition of release or any medication that's not prescribed to him or any illegal drugs. And we will appoint the Office of the Public Defender. If they live together, he can return one time with law enforcement to obtain his belongings while this is pending.
Thank you, Your Honor.
Can you repeat the bonds for me, please?
I think I said 1,500 count one, 500 count two, 100 count three. 22 CF 1472, we do find probable cause. This relates to an April 23rd incident. I think the officer took a complaint from the same alleged victim there. So there's probable cause for domestic violence battery by strangulation. We'd set his bond amount of $2,000 as to that case. Same conditions of no contact, no firearms, separate residences, no alcohol, also no non-prescribed medication, and we'll appoint the Office of the Public Defender both of these cases. Okay? Thank you, Mr. McWhite. Christine, is it Nugent?
President approaching, Your Honor.
Good afternoon. Are you Miss Nugent?
Yes, I am.
All right, Miss Nugent. I've reviewed the police report. We do find probable cause for one count of domestic violence battery. You can set the bond in the amount of $1,500. We would order no contact as a condition of release with Edward Pavlik. He may have left, if I read this correctly, but we can't have you living together while this is pending, so you do need to maintain separate residences. If he's gone, you're welcome to go back there, but if he's still there, you can't, okay?
I have nowhere to go.
Well,
I just moved from New York.
If I may have one moment, Your Honor.
yeah, go ahead.
We are ready to proceed, Your Honor.
He told the police officer that he would go somewhere else, so I just don't know. But ma'am, when we haven't had a chance to speak with him to get his thoughts, I do believe it's necessary to order that you maintain separate residences. So you would have to find somewhere else to stay if he's still there. If he's not there, you're welcome to go there. If he is there, you can return one time with law enforcement to obtain your belongings. And we'll appoint the office of the public defender. You're not to possess any weapons or firearms. If you do have any firearms, those would be surrendered to law enforcement within 24 hours of release, okay?
Okay, thank you.
Thank you, ma'am. Good luck. Matthew Slike, is it?
He is present and approaching, Your Honor.
Good afternoon. Are you Mr. Is it Slike?
Slike.
Slike, yes, sir. All right, Mr. Slike, I've reviewed the police report. We do find probable cause for one count of child abuse without great bodily harm, and we'd set the bond amount of $1,000 there. One count of domestic violence battery, and we'd set that in the amount of $500. Does anyone know if DCF was called on this?
No, Your Honor.
Um,
We're unaware if they were called. Not sure.
Mr. Mancini, do you know?
I only have the arrest affidavit, Your Honor, and there was no indication that they were called from that.
Because it's sort of the same thing, Mr. Slike. Without knowing much more, I'm going to have to order that you have no contact with your son while this is pending. You also need to maintain a separate residence, okay? So I don't know if his mom has him there still. If so, you need to find somewhere else to stay while this is being worked out. If he's gone, you're welcome to go back. But if he's still there, we would allow you to go back one time with law enforcement to obtain your belongings, okay?
Yes.
We will appoint the office of the public defender to represent you, and they should be able to answer questions for you also, okay? All right, thank you, Mr. Slake. All right, Ashley Story?
He is present and approaching, Your Honor. If I may have one moment with this client.
Yes, sir.
We are ready to proceed, Your Honor, and defense at this time would be requesting a waiver of the reading of the charges.
Okay, and you're Miss Story?
Yes, sir.
All right, so she qualifies for pretrial release. She's welcome to do that, okay? And we can appoint the office of the public defender. Probable cause is found for what she was brought in for, okay? All right, good luck, ma'am. Clifford Beasley, is he there?
He is actually detoxing, Your Honor. I would request a 24-hour reset.
He was reset from yesterday.
Is he from yesterday?
I'll tell you.
I know he was reset before. I don't remember if we reset him from yesterday or not.
I'll tell you.
I do believe he is still detoxing, Your Honor. If possible, could we request to have him brought when he is finally released from detox?
What's from yesterday?
It was yesterday. That's okay with me as long as we don't lose track of him, but the jail's pretty good about that. So why don't we just do this just to be safe? We'll reset it for tomorrow, and either he's there or not, and it can continue to be reset as necessary, okay?
Yes, Your Honor.
All right, another reset was, it came in as a John Doe, and I forget what his real name was. Is it Cabrera? Cabrera, is Mr. Cabrera there?
No, he has refused to come today, Your Honor. I have not had a chance to personally speak with him. I request a reset so we can give it one more shot, or I could have somebody from my office speak to him before we wait.
Well, he's gonna have a bond. Did he qualify for PTR?
No, Your Honor.
No, he didn't. Okay. It's a trespass. Let's just do it now since we reset him from yesterday. Probable cause for trespass. We can set his bond in the amount of $500. He's not returned to the racetrack, 2001 West Vine Street. You will appoint the PD. Okay. Thank you.
So we are accepting his name in open court because
That's fine.
we don't have Any more information?
Yeah, whatever, then, someone got his name and changed the arrest report, so it's Cabrera, right? How about Christopher Robert Handy?
He's present and approaching, Your Honor.
You Mr. Handy?
Yes, Your Honor.
All right, Mr. Handy, I think you had a arrest warrant out of Orange County. Right now, it's no bond, okay? So arrangements will be made to get you to Orange County to see the judge there, okay? And we can appoint the Office of the Public Defender to represent your interests while you're here in the Osceola County Jail, okay? Thank you, sir. Austin Spencer?
Present and approaching, Your Honor.
That's the one I talked to you yesterday about the.
Mr. Spencer, is that right?
Yes, sir.
All right, so Mr. Spencer did come in on a new arrest, and we did find probable cause for one count of possession of methamphetamine without a prescription. And I think I said his bond, did I set it to 1,500?
Yes, I'm looking at.
1,500 bond there, and then also drug paraphernalia, possession, $500 bond. So giving him bond on that case. He was also out on bond, what we learned yesterday, in two cases, 21 CF 2102 and 21 CF 2057, and those also involved similar drug possession. So I wanted him brought over because it's my intention to forfeit those bonds, having been picked up on something similar as well. So we gave him a bond on the new case. We're forfeiting the bonds on the others. So Mr. Spencer, I'm going to appoint the PD's office to represent you. They'll know what to do about seeing if the judge in those other cases will reinstate or reset a bond for you, okay?
So I don't have a bond, or I do have a bond right now?
You have a bond on the newest case you were brought in on. The other two cases that you were out on bond for, I did revoke those. Okay, so your lawyers will know what to do. Apologize for that, but I think it's the best thing to do under the circumstances, okay? Thank you, sir. Mr. Mancini, you have anyone else?
I believe that's all for today, Your Honor, from the jail.
Have a good weekend.
You too. Take care, Your Honor.
All right, Osceola, can you guys hear me?
Yes, Judge. Alicia Smith on behalf of the Public Defender's Office.
All right, good to see you. First case is Alexander Bakalitz.
Can we reset him, Judge?
Okay.
And then can we do Glantley next?
Sure, let's see. You said Glant,
He's in the back.
as in a G, with a G?
Glantley.
Okay.
Yes, sir. Yes, Judge.
All right, yeah, there it is. Gladney. Okay, Reuben Gladney. Come on up. All right, sir, please tell me your name.
Reuben Gladney.
Mr. Gladney, you have been arrested on a charge of aggravated assault with a deadly weapon, to wit, a rifle. I've examined the arrest affidavit. I do find probable cause for that offense. Your bond is presently set at no bond. Would you like to have the public defender appointed to represent you temporarily?
Yes, sir.
All right.
I don't know what that means.
Pardon me?
I don't know what that means.
Well,
I
it
don't know
means
what that means, but
that lady standing in front of you is with the public defender's office. It means that she'll act as your attorney temporarily until you get before the judge at arraignment, where he'll determine whether the public defender will represent you throughout the case, or you can get your own attorney, but for now. All right?
yes, sir.
Okay, so right now you are being held with aggravated assault, as I said, with no bond. Does counsel want to be heard?
Yes, Judge. We asked for a bond in this case.
All right. I believe any
He doesn't-
Go ahead. State.
So I'm sorry, the charge doesn't qualify for pretrial release, but he doesn't have any prior, so we'd ask for a $1,000 bond in the case.
State.
Did I hear that there aren't any priors?
Yeah, he, according to this, he qualifies for pretrial release, does not have any priors.
Your Honor, based on the affidavit and the fact that there are victims in this case, the state would request that it stayed at no bond. What is the legal basis the court could hold him on no bond? I believe. Your Honor, the state would request a reasonable monetary bond then.
I am going to set bond with PTR conditions. This case, I believe, let me just look. All right. I'm going to set the bond at $2,500 with PTR conditions. You are to have no contact with the victim in this case or any witness to this matter. The specific victim in this case is, let me see, which there's a number of people involved in this case. I believe
his wife.
It's Tammy. The victim is Tammy Gladney. And there are the children involved, who I don't need to name. And I believe Joshua Gladney is also one of the, one of the witnesses. So you'd have no contact with them. You're going to have to maintain a separate residence from the victim in this case. Any other conditions that either side, any other comments either side wants to make about the conditions of release?
Not from the
No, Judge, I just want to be clear, the no contact is with Tammy and Joshua Gladney?
Tammy and Joshua, yes.
Okay.
All right.
Your Honor?
Yes.
Your Honor?
Yes.
Pat Hill on behalf of... I would request no weapons or firearms and must surrender any.
Yes, I sort of assumed that was part of it, but you're right, absolutely. You're not allowed to possess any firearms, and any firearms that you presently own will have to be surrendered to the Osceola County Sheriff's Office for safekeeping.
Yes, they were, sir.
All right, very well.
According to the police report, they were taken.
Pardon me?
According to the police report, they were removed from the home already.
Well, he could potentially have other weapons that were not. So if there are any other weapons you own, any other firearms you own, you have to turn those in as well. All right?
Okay.
Understood?
Yes, sir.
All right, very good.
Yes, sir.
Thank you. I didn't do the first one. No, I didn't do it. No, because they wanted to do Gladney first. No, that's this one.
Both of this was reset.
Oh, that's right, reset, okay. Yeah. All right, next case we have is Justin Boudreau. Good morning, what is your name?
Justin Boudreau.
You were arrested on a warrant for violation of probation out of Osceola County. The bond amount is no bond, and you'll be held on no bond until such time as you appear before the judge that issues the warrant. Would you like to have the public defender temporarily appointed to represent you?
Yes.
All right, public defender will be temporarily appointed. Thank you. Next case is Jose Concepcion. Please state your name, sir.
Jose Concepcion.
Mr. Concepcion, you have been arrested on charges, 6 charges battery, domestic violence by strangulation, grand theft, kidnapping, tampering, I think this is tampering with evidence, and burglary with an assault or battery therein. I have examined the affidavit. Does counsel, well, first of all, would you like to have the public defender appointed to represent you temporarily?
Yes.
All right, then the public defender will be appointed to represent you. Would either counsel like to be heard on probable cause?
Yes, Judge. Defense has a probable cause argument as to the grand theft and the burglary charge specifically. As to the burglary, according to the police report, Mr. Concepcion had a key and a key was used in order to enter the home. As to the grand theft, while that would likely give rise to PC for the tampering charge in terms of taking the phone, there's nothing to indicate that he ever left the home with the phone or that the phone was actually stolen in any way.
All right, counsel, would state like to be heard?
Your Honor, just on that argument, the affidavit does state that the victim made it clear that he did not reside in the home, and he didn't have any property there, so.
As to the grand theft, I don't find probable cause on that offense. But on the burglary, I did some research. The statute indicates that if he is allowed entry by permission and then fails to leave when instructed and commits with the intent to commit a crime therein, that's burglary. And the affidavit indicates that though he was entered with the key that he was given, he was told to leave, did not, and then continued to commit crimes after that. So I do find probable cause on the burglary. So as to the grand theft, it'll be ROR. As to the other amounts, at this point, there is no bond set on battery, count 1, strangulation, count 2, and burglary with an assault or battery, count 6. Does counsel want to be heard on any of that?
Yes, Judge. Just one other thing to note in terms of the burglary, and it could just be the order that is written in the police report. The way it's written in the police report, all the offenses occurred prior to her asking him to leave, so I don't know if that would change the court's opinion in terms of entering with the intent to commit the offense if the offenses were committed prior to the consent to be within was withdrawn.
Okay, let me, I looked at that and I well, it says here that Christina said that she told Jose to leave the residence multiple times, but he refused to do so. Christina then said Jose forced her to take a shower by washing herself, and then continues to say that he beat her after that. So I do find that there is sufficient evidence and probable cause on burglary with an assault.
In terms of bond, I'd ask that a bond be set as to all of the counts. I know typically domestic cases are zero bounded until they see the judge, so he's entitled to bond as to counts 1 through 5. I would argue that he's also entitled to bond as to count 6 unless the court finds proof evident presumption correct.
State want to be heard?
Yes, Your Honor, the state has no objection to setting bond to counts 1, 2, 3 is ROR to 5, but the state would ask for no bond on count 6, and then I also, the kidnapping, I believe, is also on the bond schedule.
I'm not sure that it's a first-degree PBL unless a weapon is used. I'm just not certain.
Oh, I have it here as...
It is?
I have it listed, just
Well,
kidnapping as no bond, 1 PBL.
Well, since the bond here is $3,000, I don't think I can increase it right now.
The
However,
state, sure, the state would then just ask to remain count 6 with no bond.
I do find that proof is evident presumption great based on the information in the affidavit. So I am going to set on count 1, battery, $500 bond. On count 2, strangulation, a $500 bond. And I'm going to maintain count 6, the burglary with assault or battery, as a no bond. So, sir, you'll be held on no bond pending future proceedings in the case. Huh? They're stayed, yeah. All the other 2 bonds are stayed. And so then count 3 grand theft is ROR, so I don't find probable cause. All right, thank you, sir. Have a seat.
Thank you.
All right, next is Mr. Corbin. Joshua Corbin, there you are.
Yes, sir.
All right, sir, you have been arrested because you failed to appear. At this point, the judge has issued a capias with no bond, so you will be held on no bond until such time as you see the judge in that case. Thank you.
Thank you, sir.
No, I assume public defender's already involved or will be.
We were previously appointed.
That's what I thought, yeah. All right, next case is Odessa Devine.
Bonded.
Bonded, okay. Francisco Enriquez Romero.
Bonded as well.
Bonded, all right. Brenda Good.
She's approaching.
All right. Ms. Good, you are here on 2 arrest affidavits. The first is for driving under the influence, count 1, count 2, driving under the influence with property damage. The court does find probable cause on both those offenses. Your bonds on those offenses are $500 for the first count and $1,000 for the second count. On the count of resisting with violence, the court does find probable cause on that as well, and your bond on that is $1,000. Would you like to have the public defender temporarily appointed to represent you?
Yes, please.
You do? All right. Public defender is appointed. You do qualify for pretrial release. Would counsel like to be heard?
Yes, Judge, we'd ask for straight pretrial release in this case. She doesn't have any priors.
All right, court will authorize pretrial release on all those charges. All right, thank you.
Thank you.
All right, next case is Mr. Hill, Benny Hill.
Hospital? He's in the hospital, Judge. Can we reset him?
In the hospital, all right, reset, is in the hospital. Benjamin Kilgore. Mr. Kilgore, you're charged with operating a boat with an unlawful breath alcohol or blood alcohol level, breath alcohol level of 0.8 or higher. I've read and I do find probable cause in this case. You are eligible for pretrial release, and so the court will authorize pretrial release at this time. Do you wish the court to consider appointing the public defender temporarily, or do you think you're going to hire your own attorney?
I guess I'll hire my own.
All right, very good then. You should be released on PTR. Thank you, sir.
Thank you.
So you'll get out there.
All right, Matthews King. Yes, sir, you have been arrested on a charge of dating violence. I've read the arrest affidavit and I do find probable cause for that offense. Would you like the court to consider appointing the public defender temporarily to represent you?
Yes.
All right, the court appoints the public defender. At this time, you are being held on no bond. Would counsel like to be heard?
Yes, Judge.
Why am I?
Yes, Judge, it's a misdemeanor battery, Judge, so he's entitled to a bond, so we'd ask for a $500 bond in this case.
State, would you like to be heard?
Does PTR have any history on this defense?
Yeah, apparently, it says he meets the criteria for PTR, but it says 3 prior domestic battery arrests, different victims.
That's correct, Your Honor. Battery domestic in 2012, another one in 2015, and one in 2016.
Well, Judge, if he does qualify for PTR, I would ask for straight PTR then.
Were those just
He would
arrests?
qualify for a bond.
Okay, were those just?
Due to the history, he would.
No, that's it. Go ahead and finish.
I'm sorry, Your Honor.
No, not at all. Were those arrests, just arrests, or arrests with conviction?
They were all dropped.
All dropped. All right. I'm going to set bond in the amount of $1,000 with PTR.
Judge, I'd ask for just bond or PTR.
I understand. You're not to have any contact of any kind with the victim in this case. You're not to call her, you're not to text her. More importantly, you're not to ask anyone else to do that. In other words, you can't call your mother or your brother or your buddy and have them call her and talk to her. You understand that?
Yeah.
Okay. The only person that is allowed to call on your behalf and speak to the victim is your attorney. You understand that?
Yes, sir.
All right. Thank you.
Your Honor, I'd
Oh,
ask
I'm
that
sorry.
they-
One more thing. Hold on. Yes.
That they also maintain separate residences and that he not return.
Yes. You have to maintain a separate residence. From the victim.
I was gonna say that that's my residence, and she hasn't lived with me for 2 months.
So you just have to maintain separate residence. So if she doesn't live there, you can go back.
Gotcha.
So it's just maintain separate residence, Judge?
And no contact.
Okay, no contact and maintain separate residence, because my
Correct.
understanding is it's his residence. Okay.
Well, I mean,
I know what we did yesterday, maintain separate residence. So long as she's not there, he can go back.
correct.
Okay. So as long as she's not there, you can go back.
All right. Emerson Lewis. Emerson Lewis.
He's coming, Judge.
Oh, okay. All right, sir, you have been, you've been arrested for, let me look at this, I'm not sure I'm getting this right, for 3 offenses. They are driving while license revoked or suspended, and giving a false name to a law enforcement officer. I find and the third is that those acts violated a probation or community control that you are presently on. I find probable cause for those offenses, and at this
Judge,
point...
I'm sorry.
Yes.
I don't have a given false name. I think that might have been what he was on probation for. I have a resisting without and a
okay.
driving charge.
I'm sorry. No, thank you for correcting me. Let me rephrase that. The new offense is driving on a suspended driver's license as a habitual offender. That's the new offense. And you're right. The probations he was on were for the 2 crimes I mentioned before. So my apologies for mixing that up. On the probation violation, you're being held on no bond, and that will be stayed until such time as you see the judge in the case. On the suspended license habitual offender case, I do find probable cause on that as well. And your bond on that is $2,500.
And then they're resisting.
Oh, there it is, hidden back behind there. That's right. You also have another arrest affidavit for misdemeanor of obstructing an officer without violence. I do find probable cause for that as well, and that the bond on that matter is $500. Would you like to have the public defender appointed temporarily to represent you?
Yeah.
Was that a yes?
Yeah.
All right, then public defender will be appointed. Thank you, sir. Okay, next is John McClendon. Okay, so you were arrested for failure to appear. Warrant was issued by a judge in a 2016 traffic court case. Your bond is set at none, and you will be stayed at none until you see the judge. Which I assume the public defender is probably already appointed, so I'm not going to worry about that. All right, thank you, sir.
Can we appoint us just to be safe if we weren't, Judge?
Sure. Let's appoint the public defender in case that didn't happen already. Okay, Mary Nelson. Mary Nelson, oh, there she is. Ms. Nelson, you have been arrested on 3 charges. One is possession of cocaine, one is possession of drug paraphernalia, and the other is operating a motor vehicle without a valid driver's license. I find probable cause exists as to all 3. Your bonds are set at $1,500 on the cocaine charge, $500 on the paraphernalia charge, and $500 on the no valid driver's license charge. That, if you bond out, it will be with PTR, so you'll have bond with PTR. Would you like the public defender appointed temporarily? If she answered, I couldn't hear it.
You got her. She said yes, Judge.
All right, public defender will be appointed. All right, next is Danny Pastrana.
Your Honor,
Yes.
Ms. Nelson is currently out on mental health PTR as to case number 19CT726.
Okay.
Will you be taking any action on that?
I was not aware of, oh, that's this one. No, I'm not going to take any action on it.
Thank you, Your Honor.
Thank you. It was, it is 2019
Case number?
CT726.
That's correct, Your Honor.
Yep, I do see it there, I just didn't follow the abbreviation. All right. Morning, Mr. Pastrana. You are being held on a charge of battery in a domestic situation. I've looked at the affidavit and I do find probable cause exists. Would you like to have the public defender appointed to temporarily represent you?
Yes, sir.
All right, public defender will be appointed. You're presently held on no bond. Counsel like to be heard?
Yes, Judge. I believe he qualifies for pretrial release, so we'd ask for pretrial release as to this case.
Anything from the state?
Does he have any history, any priors?
Does he have any priors, PTR?
PTR, I'm sorry.
Between the years 2003 and 2005, as a juvenile, he had a passing counterfeit bills, aggravated battery on a pregnant woman, which was no prost, VOPs, fleeing and eluding, resisting without, and FTAs. As an adult, 2008 ag battery also dropped, VOP, and an arson in 2017, which was also dropped.
Your Honor, the state would just request appropriate conditions, no contact with the victim, no return, separate residences.
Yeah, the state will grant, the court will grant PTR in the case. I don't believe that these two people are presently living together. They have children together. At this point, you're going to be released on PTR. You have to maintain a separate residence from the victim. You have are not allowed to have any contact with the victim. As far as seeing your children, do you have a parenting plan in place?
Yes, we take turns, 1 week her, 1 week me, but we have graduation this week as well, so I don't know how that's gonna work.
They alternate weekends, but graduation is this week.
Graduation from what?
My daughter's graduation,
Like BPK, elementary.
elementary.
Elementary school graduation.
I'm sorry, whose graduation?
His daughter graduates from elementary school this week.
From elementary school. All right. You can attend the graduation, but while there, you are not to have any contact with her. So in other words,
yes, sir.
You don't talk to her, you don't look at her, you sit in a completely different part of the building. And as far as if you need to communicate, you're allowed to communicate with her about the children only, and that communication is to be non-hostile. You all right? Okay, you understand?
Yes.
Yes,
sir.
If you have a problem with something she's doing, you cannot argue with her about it. You cannot yell at her about it. All of your communication with her can only be about the kids, and it has to be non-hostile. Understand?
Yes, sir, I understand. Thank you.
All right, very good. Thank you. Samuel Taylor. Ms. Taylor, you were charged with trespass after warning for going into a place that you were told you weren't allowed to go. That's actually Wawa. I've looked at the case, and I do find probable cause. At this point, your bond is set at $250. I'm going to add PTR as a condition of your bond, so if you bond out, you have to follow the conditions of PTR. Apparently, you have active warrants.
It's just a trespass.
Pardon me?
I'm sorry, Judge. I was just gonna say, since it was only a trespass, would the court consider either bond or pretrial release? Okay. Well, I don't think he qualifies for straight pretrial release because of the active cases, but I would ask for just a straight bond then.
Well, it says he does qualify for PTR. It says yes. Is that true? Does he qualify for PTR?
He qualifies with the bond, Your Honor,
With
due
the
to
bond.
the active warrants. Yes.
Okay, well then we'll set it at $250 with PTR. All right. Thank you, sir.
Public defender appointed?
Sure, yeah. Next is Mark Tejada. Mr. Tejada, well, please tell me your name.
Mark Tejada.
All right. You here on two arrest affidavits, one charging petty theft, resisting an officer with violence, and battery on a law enforcement officer. I find probable causes to all three of those offenses. On the other case, pardon?
I'm sorry, Judge. I did have a probable cause argument as to the resisting charge since at the time he was already in custody. If there could be, I understand the bat Leo, but in terms of the resisting, since he was already in custody, would it still be resisting?
All
or would
right.
it just go to the bat Leo?
Let's see. Well, I don't think it matters whether he's arrested or not. I think the same act can violate both statutes. They may not be able to be convicted of both, but I think he charged with both. So I think there's probable cause for both. And the bonds on those are petty theft, $500, resisting officer with violence, $1,000, and battery on a Leo is $2,500. You do not qualify for PTR, and you have another arrest affidavit. This is for 2 counts. One is possession of drug paraphernalia and possession of controlled substance. I do not find probable cause as to those 2 cases. I state I don't find probable cause because I don't find anything that makes the items more probably in possession of one person than the other, and I don't know if there's any supplement they can do to that. So I'm going to ROR him on those 2 charges. Would you like the public defender appointed, sir? Did I already do that?
Yes, sir.
Did I appoint the PD?
Yes, sir.
Okay. Yeah, I appoint the PD. And I retroactively appoint the PD back to when she made her argument.
Thank you, Judge.
You're welcome. Okay. Thank you, sir. This is David Rivera.
He's coming, Judge. He's in a wheelchair.
No problem. No problem. Mr. Rivera, you have been arrested on a warrant for, this is a failure to appear or a new crime. Anyway, the bond on the warrant on a misdemeanor petty theft is set at $5,000. You can bond out for that amount. If you can't, then it'll remain stayed until you see the judge that issued the warrant. Sir, do you already have the public defender appointed in the misdemeanor case?
It's a Lake County case, Judge.
Lake County. Oh, okay. Well, then I won't do anything. Thank you, sir. That's it. They should be coming to get you from Lake County, I think within 24 hours, maybe. I don't know if this little thing I have up here is for Osceola too. There's a little note stuck up here. Well, anyway, as soon as they can get to you, they'll get you over to Lake County. Thank you, sir.
Okay. I got a question.
Okay, Mr. Izquierdo Acosta.
He needs the interpreter, Judge, but he's coming.
All right. Do we have the interpreter?
Yes, Judge.
Okay. Oh, she's up there?
The interpreter is connected, Judge.
Hello.
Can Your Honor hear the interpreter?
All right, very well, thank you. So he's just going to listen to you through the speakers down there. Is that how it works?
Yes, correct. It
All right.
will have to be done consecutively.
And I'll talk in chopped sentences. Please tell me your name.
¿Cómo se llama usted? ¿Cómo se llama usted?
Reinaldo Izquierdo.
Reinaldo Izquierdo.
Sir, you have been arrested on 2 charges, the first of which is petty theft.
Usted ha sido arrestado por 2 cargos. El primero es hurto menor.
The court finds probable causes to that charge.
El juez determina que hay motivo fundado para ese cargo.
And your bond is set at $250.
Y la fianza en ese cargo es de $250.
You're also charged in a separate case with petty theft.
También se le acusa de hurto menor en un caso distinto.
The court finds probable causes to that charge, and your bond is set at $250.
El juez también determina que existe motivo fundado para ese caso y la fianza es de $250.
Condition of bond will be PTR.
La condición de la fianza será que estará bajo el Departamento de Libertad Provisional.
And you are not permitted to return to the location where the offense occurred, which is 4692 West Earl Bronson Highway. It's a Circle K.
Y también la otra condición es que le está prohibido regresar al lugar de los hechos, donde la dirección es 4652 al oeste de la Earl Bronson Highway, que es una gasolinera Circle K.
You understand?
¿Entendió?
Okay.
Okay.
Yes. Do you want the public defender appointed to represent you temporarily?
¿Quiere que se le nombre a un defensor público provisionalmente?
Yeah.
Public defender will be appointed.
Se le nombra un defensor público entonces.
Thank you, sir. You can have a seat.
Gracias, tome asiento.
Your Honor?
Yes.
He currently is on probation in case number 18 CT 1452. That's a duelist charge. Will you be finding an on view today?
I'm sorry, what was the last thing you said?
Will you be finding an on view violation or taking no action?
Take no action.
Thank you, Your Honor.
Can you give me that case number again?
18 CT 1452.
All right, sir, thank you. All right, next case is Rafael Santiago Corsino.
Is he still in the hospital? He's still in the hospital?
No,
He's still in the hospital, Judge.
He's still in the hospital? All right, we'll reset that one. Judge Wilson tomorrow. Okay, last is Peter Francis Keller. Mr. Keller, you have been arrested on a for failure to appear on a battery charge, 18 MM 3608. Your bond has been set by the judge at $2,999. It's almost like she's selling a car. Make it 3,000. I think it's easier to write, right? So you will be kept in. If you can make bond, then you'll be released from jail. If not, then that will be stayed until you see the judge that set it. Do you have the public defender appointed to you in that case already?
No, sir, Your Honor, I was never aware or received.
No, Judge Wilson will be here tomorrow.
Okay, same time still, though?
As far as I know.
Okay.
All right, thank you.
Thank you, Judge.
Same bat time, same bat channel. All right, so we want to do the pullouts, right? Oh, okay. Well, were all those in the same?
Yep.
Okay, good. Then I already did them. Okay. Oh, okay. I'll read them from here. All right.
Your Honor, just a quick question from the interpreter. If any of the cases have an actual case number, if they can please be given to the interpreter.
Oh, I'll read it out.
Thank you.
All right, first case is Juan Pedro Gomez. And that is case 19 CF 7574. I'm sorry, what now? Yeah, we're starting the move-ups. Yes, going to stop after the move-ups, and then we'll take a break. I'll finish reading the rest of them, and then we'll go. Should be about maybe another 30 minutes or so of reading, and we'll get moving. All right, now they have the headphones on, so will I be hearing the interpreter or?
No, Your Honor.
I need an interpreter.
We'll do it simultaneously. They'll hear me through the headset, and when he responds, then you'll hear it over the loudspeaker.
Very good. All right, so please tell me your name.
Juan Gomez.
Mr. Gomez, you are here on 3 charges, battery by strangulation involving domestic violence, attempted aggravated battery with a deadly weapon, and battery, another, again, an act of domestic violence. I found probable cause as to all 3 of those offenses. Would you like to have the public defender appointed to you?
Si me puedes traducir, yes.
Yes, Your Honor, I'm sorry. The interpreter forgot to press the pedal so that he could hear me. I completely apologize. Can you read the charges again?
Yes, the charges are battery by strangulation as an act of domestic violence, attempted aggravated battery with a deadly weapon, and battery, an act of domestic violence. Question was, do you wish to have the public defender appointed to represent you on these charges?
¿Necesario? No sé, yo es la primera vez que estoy acá.
Is it necessary, or because I don't know, this is the first time I'm here.
Tengo los medios y...
Sir, do you have the money to hire your own attorney?
Yes.
You do?
Yes.
All right. Then public defender will not be appointed. Right now, you are being held on no bond, but you are entitled to a bond on these charges. Does the state want to be heard on what the bond should be set?
Your Honor, the state would just ask for a reasonable monetary bond. I believe it just has to be set, or at least with the aggravated battery, it has to be set here, so.
All right. And I believe I'm addressing the state, I believe the relationship is uncle and nephew, so it's not a intimate partner
Right,
case.
they live together, but it's uncle and nephew.
All right. Sir, I'm going to set bond in this matter on the battery case at $500. I'm going to set bond on the aggravated battery case at $1,000. And I'm going to set bond on the other battery case at $500 as well. A condition of release is that you're going to have to maintain a separate residence from your uncle, who's the victim in this case. You're going to have to move out, find your own place, and you're not allowed to have any contact. Is the victim here, by the way? Okay. And you're not allowed to have any contact with the victim.
Okay.
Do you understand that?
Yes, sir.
Oh, sorry. All right, sir. Thank you.
Thank you.
Next is Virginia Orellana. Please tell me your name.
Romeo Orellana.
Romeo
And-
Orellana.
You are here because you've been arrested on a charge of battery as a crime of domestic violence. Would you like to have the public defender appointed to represent you, at least temporarily? Oh, no, we have the affidavit.
Sí.
All right.
Yes.
I have your affidavit here, and I do find you qualify, so the public defender will be appointed to represent you. Presently, you're being held on no bond as an act of domestic violence. Would counsel like to be heard?
May we hear from the victim first, and then I'll make argument?
Certainly. Sir, could you please tell me your name?
Yeah, my name is Ludi Delis.
All right. Do you need the services of an interpreter?
No, I'm good.
Okay, good. What would you like to tell me?
Yeah, pretty much, I mean, what I'd like to say is she's the mother of my child. For her to be in where she is right now, she's not even supposed to be there. So at this point now, and I think like, I'd set up a bond for her to release her today. That would be the perfect decision for us on the house because like, on a home with 3 children, I mean, we got a 10-month-old baby, and the 10-month-old baby is still breastfed as well because of her So, I mean, she's not a violent person whatsoever at all. So you just like the jealousy thing just get out of hand. But she didn't physically hit me or push me or anything like that at all. So, pretty much all I would be asking the court is to pretty much, I understand you heard that before, but I would like maybe the charge to be dropped because like myself as well, I'm a former Orange County deputy as well. So that's me like me and her, there's no like, violence history for me. There's no violence history for her.
Right.
So things just get out of hand, and then I was not even expecting that taking her to jail yesterday, but that thing been really put a lot of tolls on us and me and plus the child at the house as well.
Okay, that's fine. Are you in any fear of her?
Oh, no.
May I
But-
inquire?
Sure.
Would you like to have contact with Miss?
I may be able to
Lena?
cut you short. I'm going to ROR her.
Oh, okay.
Yeah.
All right.
Okay?
With no hostile
I
contact.
didn't want to, I shouldn't short circuit the state. If you want to say something, it seems like that's appropriate.
Yes, the state was just going to request then a no hostile contact order.
Right, I was going to do that too. So, sir, we're going to release her.
Yes.
As far as whether the charges go forward, you need to call the state attorney's office and talk to them about that. The court doesn't have any thing in that. Going to be released on your own recognizance. Your only condition is you're not to have any hostile contact with him. In other words, you're not allowed to get into a fight with him. All right? So if something comes up that gets heated, you got to walk away. Okay, you just got to walk away. All right?
Okay.
Are we gonna be able to?
Oh, immigration hold? Oh,
Don't they have 24 hours to pick her up or something like that?
No, it's not necessary.
It usually depends if it's like just a detainer or if it's just a warrant. It depends if she's got an open case or not, like if she has
All
an
right.
A number. But they'll come. They have a certain amount of time to come pick her up, and if they don't, she gets out.
just make,
Thank you.
let me,
What just happened?
hold on, let me explain it to you, and then, she can listen. Apparently, there's an immigration hold on her, so that may keep her in a little bit longer. I don't know anything about it, they're just informing me that it's there, and apparently, I guess council was saying they've got 24 hours to take action on that, or she gets out. So she may not get out today, but as far as this charge goes, she's free, or she's able to be free, but the detention hold may keep her there.
So that's meaning when you come to the immigration hold, because me and her were in the process of getting all that thing straightened out.
I don't, she doesn't know either. She just knows the computer says this, and that's all we can tell you. Yes?
When you go downstairs, stop by Inmate Records in the window and talk with them down there, and they can explain to you what's going to happen. Yeah, that will help you. It'll shed some light on it. Okay?
Okay, so as of right now, she is free on the charges, but on the immigration process, that's on the question now.
Yes. Okay. Ma'am, do you understand what we've been talking about? Very good. Thank you.
Your Honor, I'm sorry, is there a case number for this case?
Oh, yes, I'm sorry. There is. It's 2019 MM 4423.
Thank you.
Okay. Next case is Carlos Iona, and this is 2019 MM 4430. Sir, please tell me your name.
Carlos Iona.
All right, sir,
Carlos,
you
I know.
have been arrested on a charge of battery as an act of dating violence. I've examined the arrest affidavit, and I do find probable cause for that offense. Would you like to have the public defender appointed to represent you?
If it's possible. If it's possible.
Can the interpreter hear him?
Can you hear him?
Yes, he's answered in English.
What did he say?
If it's possible, that's what he just said.
If it's possible.
Yeah, he
Okay,
said it in English.
I didn't hear that. All right. Don't have an affidavit here. That's odd. Nope. Sir, how much money do you have in the bank?
No money.
None? How much money do you make a week?
At this moment,
I'm sorry, if the defendant is not in an interpreter, then
500.
Okay. Do you need the interpreter, or do you understand English well enough to talk to me?
Yeah, at this moment I can talk in English.
Okay, we'll take those off. Okay, we're going to excuse the interpreter. I believe that's the last case we had, right? Yep, okay. Thank you, sir. You're excused.
Thank you, Judge. Thank you.
All right. So how much money do you make, you said, a week?
Maybe 450 to 500.
Well, here's what it would do. I'm going to temporarily appoint a public defender pending your arraignment, where a judge would make a more thorough inquiry and a final decision. But I'm going to appoint a public defender for purposes of this event. So you're presently being held on no bond on this case. You also have a second charge, that is driving under the influence with an unlawful blood alcohol level. And I do find probable cause as to that offense as well. The bond on that is $500. Does counsel want to be heard on bond on the battery charge?
There's an alleged victim here. I want to let her testify, and then I'll make my argument.
All right. Please tell me your name.
Alexandra Ale.
If you could get a little bit closer, I can't really hear you.
I'm sick. Alexandra Ale.
Okay. And are you the victim in this case?
Yes.
Okay. What would you like to tell me?
I've been in a verbally abusive relationship for a long time with this man, and my intent yesterday was for the officer to escort us because he was getting aggressive and putting me down and insulting me. And he gets like that when he drinks. He changes personality. I don't think anybody should be in jail, but he needs help. My main concern also is his family. They already started harassing me last night, and every time he gets out of control, I have to deal with his actions. I go home and I start getting threats from his brothers, harassment from his family, and I don't want his family to harass me anymore. So, but I do feel he needs help.
Well, two things. The first is that, you know, alcohol doesn't make people violent. It brings out things in people.
Yeah,
So-
he's done it without alcohol too.
Okay. So what can we do to, I can only order him to do things. I can't order his family to. But
I would like a no hostile contact. I have attempted to get an injunction on the brothers.
okay,
I'm gonna try it again.
all right. Do you have an injunction against him?
No, because he doesn't threaten me. His brothers do.
Okay.
He just loses control when I'm in his presence. He puts me down, a lot of verbal abuse.
Do you want to?
And yesterday he grabbed me and he tried to push me. He said he was gonna push me off the boat. All I was trying to do is put the engine in neutral because he kept putting me down and I didn't want to be there.
Okay. Do you want to not, would you prefer that he have no contact with you at all? That you just don't see him at all?
What I would like this court to do is maybe have him evaluated. Maybe he can get some type of counseling. Obviously, he has an issue with drinking. He drinks every weekend and he changes personality, and maybe like a domestic violence course so he can take responsibility for his actions because he doesn't like to accept that he has a problem.
Okay, well, those are things that a judge in a sentencing, if he were convicted, could do, and those are something that a judge, if they issue an injunction against him, could do. So I can't, as a part of pretrial release, but you know, I would encourage you to seek an injunction against him, because that will give a court the power to do the things that you've just suggested. Okay? So, but that's up to you. State want to be heard?
Yes, Your Honor. Based on what is contained in the affidavit, as well as the testimony we just heard from the victim, the state is going to request no contact at all, seeing as that seems what is most appropriate. And the state would have no objection to setting a reasonable monetary bond in this case.
Yes.
We have no objection to no contact. He does qualify for pretrial release. He has no prior arrests, no prior convictions, no criminal history at all. So we'd ask he be either a reward or, in the alternative, put on pretrial release. They don't live together, so there's no issue of an alternative address.
Can I order an alcohol evaluation as a part of PTR? Okay. Well, that's what we're going to do. I'm going to release you on pretrial release. One of the conditions of pretrial release will be that you get a drug and alcohol evaluation. You're not to have any contact with her at all. You are not to have anyone else contact her. So if we get so much as a hint that your relatives are contacting her because you have suggested they should, then you're going to be back in jail. Yes, sir. Speak to your lawyer first and say whatever you want. Yes.
Your Honor, we would, random drug and alcohol urinalysis.
Yes.
Thank you, Your Honor.
Random screen. Sorry?
Ask if he could be on PTR for both cases, given that he has no history.
That's fine, yeah. And the condition will be on both cases. That is the evaluation and the screening. I didn't want to cut you off. If you wanted to say something, if you decided not to, that's fine as well.
No.
All right, very well then. Then those will be the conditions of your release. Ma'am, I really, really encourage you that based on what you've asked, you really should get an injunction, okay? All you got to do is go down to the courthouse on Monday morning, clerk's office, and they'll walk you through it. All right? Okay, take care. All right, so that's all the interpreter cases, right? Yes. All right, so the court will be in recess for about... I'm sorry, what now? Oh, I'm sorry, the move-ups. I apologize, I forgot. Okay, all right, so Terrence McCree. Trying to get out of here too early. What's your name, sir?
Terrence McCree.
Mr. McCree, you have been arrested on charge of aggravated assault as an act of domestic violence. I have examined the arrest affidavit, and I do find probable cause to believe that you committed that offense. I believe this involves, is it your, well, this is not a question to you, it's a question to the state. This is his father, I think?
Yes, Your Honor.
Okay. So it's an aggravated assault against your father. Do find probable cause. Would you like to have the public defender appointed to represent you?
Oh, yeah. I had more to say one more time.
Well, hold on one sec. One sec. We're going to take one thing at a time, and then you'll be able to talk if you want to. Hold on.
I was saying about the charge. That's what I was saying.
Oh, yeah, we'll get there. We'll get there. I'm going to appoint the public defender to represent you. The reason that she's putting her fingers on those mic buttons is because you probably shouldn't say anything about the crime until you speak to her, because there's really not much you can say that's going to help you. It's only going to hurt you. But it's your right to speak if you want. But I would suggest you talk to her first. So, do you want to speak? Yeah. Chat with her. Let me stop you for a sec right here, because two things. One is, what you're doing right now is not really confidential, because she can hear everything you're saying. I know she's probably not gonna come and tell me, but she can, so you're smarter to wait and talk when you can talk privately with her. The other thing is, we gotta move on, so if you wanna speak, we're gonna do it right now.
Your Honor, he's incompetent to proceed on the other cases he's out on bond on. I just want to put that on the record. He was adjudicated incompetent to proceed on May 18th in the first case, and then May 18th, 2018. And on the second case, he was found incompetent to proceed on January 30th, 2019. So as of right now, he's presumed incompetent.
You know, you'd mentioned that, and I thought about that and over the evening. I don't think that's correct. I believe that a finding of insanity is presumed to carry into other cases, but I don't.
I thought the opposite.
No.
Because competency goes with the person, insanity goes with the offense.
No. Insanity, the case law is that once somebody is found insane, there's a presumption that they are insane, and it has to be rebutted. But I don't think the same goes to competence, because cases are all different. But that being said, in this case, I do have that he's out on bond.
I was out on release.
Or ROR.
He's on conditional release.
On 2 cases, and based on the seriousness of this offense, I am going to revoke bond on the other 2 cases. They are 2018 MM 386 and 2018 MM 9333. Because there's a potential that these new offenses may change the calculus of whether he's a danger to himself or others.
I understand.
Okay.
I understand what you were saying, sir. What you were saying more as I understand what you're saying. I take all the charges right here standing too. Saying what I'm saying too. What I was basically saying, you saying you had more of the charges, but you were saying you were gonna say something about the state, but you saying you were gonna say more as my charges. Now you saying my charges anyway. You said, oh, I got release and I only got 1 charge, and then every charge you got me with, as you saying I release, is not even a process charge as you had me as you was gonna have me as a felony. That's what you said what the case was, and then you said when you were coming back again, you were saying about the bond. I understand what you're saying about the bond, but you saying the cases that you had me on, you kind of had me as not can get a bond, because more you saying as the cases you got a charge on me.
So based on the fact that I have
For the record, I'm objecting.
of course, that I have revoked bond on the other 2 cases, I'm going to leave the bond on this as no bond, subject to its review by the trial judge.
Your Honor, he's entitled to a bond. It's not a punishable by life offense or capital offense.
I understand that, but he's going to have no bond on the other 2 offenses anyway. So I just don't think I just don't think piecemealing this is in his best interest. If the judge wants to set a bond, well, you know what, wait a minute, because it's going to be a felony, so it's not going to be the same judge. All right, yeah, you're right, it's not going to be the same judge, so we're not going to get this all together that way anyway. You want to be heard on the amount of monetary bond?
Your Honor, the state would just ask for a reasonable bond based on the facts.
Just once, I'd like to see a prosecutor say, I want an unreasonable bond.
Well, that wouldn't be ethical, would it be?
Then it's rather superfluous to say it at all, isn't it? $1,000 bond on the new charge.
Okay.
Oh, I'm sorry. Sir, I didn't see you there. I apologize. What is your name, sir?
Tommy McCree.
All right, Mr. McCree, you're the victim in this case?
Yes.
Did you want to say something to me?
Well, I guess y'all got it all going how you going, so I just leave it like that. But
well, I did not see you sitting over there, standing over there. So I always look over here, and I never think to look over there. So no, if you have something that you want to say, I want to hear it.
Well, I like to see him get help. I don't want him, you know, it's getting to be a problem. It's getting worse and worse. And you keep, you know, by that being your son, you try to deal with it, but it's getting out of hand, and, you know, it's kind of bad. You got to sleep with your room door locked, you know, because you don't know what kind of state of mind he in. And it's just getting out of hand, and he needs some help bad.
Well, that's one of the reasons I did what I did is
Right.
that if he gets to the level where even if he's incompetent, if he's a danger to himself or others, then the judge can, make the choice to have him committed to a state hospital as opposed to just letting him out. And I think the judge that has this case ought to make that decision, because if he's getting worse and people are in danger, then that's a different story. So that the judge will be addressing that, hopefully in the misdemeanor case, and I assume that there'll be a competency hearing on this case, and it'll be part of that too. So let him know that. All right.
Your Honor,
Nope. Yes. Sir.
I'd request a no contact order based on the victim's statements that.
Well, right now, I since I've revoked bond in the other cases, I don't want to throw an incompetent person out onto the streets with nowhere to go. So
The state would request a no hostile contact order then?
okay, yeah, no hostile contact.
Okay.
All right, sir. Be sure to keep talking to the folks get involved with, so they know that he needs help. All right. All right, sir.
So what are y'all doing now? What are they
He's
doing
gonna.
now?
He's gonna stay in jail until the judge in those misdemeanor cases has a chance to look at this and to see whether he still wants to leave him out while he's being processed for competency, or whether they want to put him in the hospital.
Right.
All right?
Okay.
All right.
How long we have to wait on that? I'm saying.
It may be a while. I don't know. I can't tell you. All right? Take care. All right. Your name, sir?
My name is Eric Lionel Holcomb, Judge.
All right, Mr. Holcomb, you were charged with the offense of urinating in public. I find probable cause that you committed that offense. Would you like to have the public defender appointed temporarily?
Yes, sir.
All right, your public defender's appointed. Your bond on this is $250. Would counsel like to be heard?
Considering this is a nonviolent city ordinance, we ask that it be released on its own recognizance because it's the state's bond bail policy to advocate for ROR in cases such as this.
The state would have no objection to an ROR.
That, or would you like to resolve the case today?
He's asking you if you want to plead guilty. Are you on probation or criminal control? Are you a U.S. citizen? Do you want to resolve your case? Okay. Yeah, do you want to do that? Do you understand your right to that? Do you understand you're not that valid? Okay. He would like to resolve his case.
All right.
Would be inclined to a credit time serve offer?
Yes.
Okay.
I shouldn't usurp your ability to give an input, but,
Oh, the state would also extend a credit time served off.
so sir, do you want to enter a plea of guilty?
Yes, I was guilty.
All right, did you pee in public?
Yes,
All right. Court's going to find you guilty of this offense. Based on the arrest affidavit, there's sufficient evidence. Do you understand all the rights on that sheet that you're waiving?
Yes.
All right, you have the advice of counsel. You're going to be sentenced to with 2 days, 2 days Orange County Jail with credit for time served. Go forth and be careful where you pee.
Thank you, sir.
All right. The next case is Lena Ferretti Woodson, and this is one that gave the state 24 hours to supplement probable cause, I believe, on the issue of intent to sell.
Yes, Your Honor, and I did not receive any supplemental information,
All
but
right.
I do believe that we have probable cause just for the possession of cocaine.
All right.
Okay.
So the court's going to find probable cause for possession of cocaine, a felony of the 3rd degree. The bond will be changed. Well, we'll get there in a minute. Did I appoint a public defender yesterday?
You did.
Okay. And does the public defender want to be heard on the subject of bond?
We just asked that you set a reasonable amount.
State, any thoughts?
Yes, Your Honor, based on the fact that there is history regarding controlled substances, the state would request $1,000 bond.
Well, this was wasn't this one of the cases where he's out on bond on a possession with intent case?
He's revoked on that case anyway, so.
Well, I
we don't-
revoked him on that case, okay.
Yeah, so
All right.
it really doesn't matter.
All right, then, oh, there, I see right there, yeah. The court will set a $500 bond on that case. Thank you, sir. Michael Waters. Yes, sir. Yes, sir. You've been arrested for the charge of uttering a forgery. Court finds probable cause in the arrest affidavit. Would you like to have the public defender appointed to represent you?
Yes, sir.
I've examined your application and you do qualify, so the public defender will be appointed. Your bond on this uttering a forgery charge is $1,000. Do you have any questions?
No, sir.
All right, thank you, sir. Stay. Yeah. Oh, I'm sorry. I missed one. I was getting so much better at this. All right, sir, what is your name?
My name is Twan Robinson.
And Mr. Robinson, you have been arrested for the charge of trespass on property after warning. The place involved was the Speedway on Clarkona-Ocoee Road. I've looked at the arrest affidavit. I do find probable cause. Your bond is set at $500. Would you like to have the public defender appointed?
Yes.
All right, you do qualify, so I'll appoint the public defender to represent you in the case. Bond's $500. All right, thank you, sir. Sir, your name?
Keith Anthony Smith, sir.
Mr. Smith, you have been arrested on a charge of battery. I do find probable cause in that case. Would you like to have the public defender appointed to represent you?
Yes.
All right, I don't have a full affidavit, so I'll just appoint him temporarily.
Okay.
Appoint the public defender temporarily. Your bond is set at $500.
He qualifies for pretrial release. We'd ask for pretrial release. He has no convictions or failures to appear.
Does he qualify?
Yes.
All right, then PTR it is. Sir?
Didn't we resolve his case yesterday, or is this something new?
My name is DeVille Williams.
Yes, sir. Mr. Williams.
Yes. Yeah, I resolved my case yesterday, but a police officer picked me up for the same thing, trespass. I plead guilty. Okay.
Well, if you already pled guilty yesterday, we don't want you to plead guilty today. Okay, this happened, well, this happened yesterday.
Yes.
So after you got out of jail yesterday, then that's when this is supposed to have happened.
Yes.
Okay. I'm not going to resolve this case today because.
When are you going to resolve it?
Well, you'll have to stay in jail until the county judge hears it, because I can't have you coming in here every day. So we're going to let you sit for a little while, and then you can resolve it with the county judge.
Okay.
All right. So your bond is $500. Would you like the public defender appointed?
Yes.
All right. Public defender's appointed in this case. Good luck. We resolved this case yesterday. Unfortunately, he went out and made another one.
No.
Okay, Mr. What's your name, sir?
Nelson Rodriguez.
All right, Mr. Rodriguez, you were arrested for the offense of camping. I do find probable cause that you committed that offense. Would you like the public defender appointed to represent you?
No,
Okay.
possible talking to you, Josh?
Sure, what do you want to talk about?
My English is no better because it's practiced every day. Sorry for my English.
That's okay.
Yeah.
He's asking for an interpreter.
Okay, what we'll have to do is reset you. I don't think can we get the interpreter back?
It's possible explain for English. I practice for my English. It's the first time here.
Sure.
I have a pacemaker coming soon and have the pills very strong for me. My high blood and me down, me fault, because my body no.
No, don't talk about the facts.
What is
Don't talk about the facts. We can fight it.
Okay, we'll have to reset him for tomorrow.
Okay.
When we can have the interpreter here.
Thank
Okay,
you.
so you'll see another judge tomorrow.
Okay.
Okay, thank you. This one. Oh, okay. Give me 1 second. This is a later arrival. What's your name, sir?
Michael Henderson.
Okay. All right, you have been arrested for the offense of having an open container of alcoholic beverage. I've read the arrest affidavit. I do find probable cause for that offense. Would you like to have the public defender appointed to represent you? All right, well, I don't have an affidavit, but we'll appoint the public defender temporarily in this matter. Your bond is set at $250.
Your Honor, we'd advocate for ROR considering that it's a nonviolent misdemeanor.
State has no objection to ROR.
All right, ROR it is. You're not going to see him back again. Well, here you'll see him, but not there. All right, sir, please tell me your name.
Cecil Dukes.
Mr. Dukes, you have been arrested on a warrant out of Hendry County.
Yes, sir.
And I don't think there's any bond on that warrant, as far as I can tell. Here we go. Yeah, no bond. Oh, it's a sex crime. Okay. So you will be held on no bond pending transfer to Hendry County. And it looks like we don't have a date and time for transport yet, but we'll get there as soon as we can.
Yes, sir.
All right, sir.
He does have reporting instructions too for,
He has what?
he has HRSO reporting instructions.
What does that mean?
Just,
I don't even know what that means. Hold on a second.
When high-risk sex offender comes across their reporting instructions, he's supposed to report when he gets out where he is at all times. So if he gets arrested, this is his address, and then once he gets out, it's a new address. Just
Okay.
reporting.
Should you get out, you have reporting requirements, so just remember that.
Yes, sir.
Okay, thank you.
All right, thank you.
Thank you.
Okay. Yes, your name?
Javette Desiree LaPointe.
All right, and you have been arrested on the charge, just a sec here, of burglary of an occupied conveyance.
We reset this yesterday because there was only probable cause for a trespass.
That's correct, Your Honor. This is also a case where I did not receive any supplemental
All right.
affidavit.
Then the court will only find probable cause for trespass in an occupied conveyance as opposed to burglary. Would you like the public defender appointed?
Yes, sir.
All right. If I haven't already done it, then I'll appoint the public defender to represent you. As far as, does either counsel be heard of the subject of bond?
We asked that you set a reasonable bond.
Okay, we'll set a bond of $500.
As far as the case she's out on bond on, no information's been filed yet, and it's been over 33 days.
All right, then I'm not doing anything about it.
Excuse me.
All right, there you go. $500. Yeah, the one I reduced to trespass.
It
Yeah.
didn't get revoked.
Am I out on bond?
Yeah, you can bond out if you want.
Am I out on bonds on something, sir?
She can explain that to you. I recall that you were out on release on another case, but it has not been filed yet. So I'm not doing anything about that one. Okay? All right. Sir, what is your name?
David Kenneth Skelly.
All right. Mr. Skelly, you have been arrested on charge of trespass on property after warning. I do find probable cause to support that crime. You're being held on $500 bond. Would you like to have the public defender appointed to represent you, at least temporarily?
She's asking you a question. Do you want a public defender?
Yes, sir. Can I explain my situation?
No, you, okay. Let me, listen to what she's saying. Stop. Let me tell you, now is not a time for you to tell me anything about your case, because there's nothing you could tell me
I'm a
that
registered student.
would matter, huh?
I'm a registered student. I used to get the ball, and I shouldn't be trespassed there. It was 8 years ago.
Okay, but I can't do anything about that now, all right?
Can I get an ROR, please?
Well, that's a good point. Do you want the public defender appointed? So the question is, can she speak for you or not?
Yes, sir.
All right, you're temporarily appointed. As far as the ROR request,
I'm a registered student. I shouldn't be trespassed.
well, sir, do you have a, where do you live?
I live by Walgreens, by the UCF, by Alafaya Trail. By
Okay, so you don't have like a regular mailing address?
no, I use the general delivery downtown. That's my mailing address, and I also have a resident. I can stay nearby at the shelter, the men's shelter, Coalition. I've lived there.
Let me stop you for a second. State, position on ROR.
Yes, Your Honor, this is a nonviolent offense. Our concern would just be being able to locate the
So,
defendant, because it's...
does that mean yay or yes or no on ROR on behalf of your state attorney?
Yes, Your Honor.
All right then, yes it is. ROR.
I will. Thank you so much, everybody.
Thank you. All right. PD's appointed temporarily because I didn't have an affidavit. Your name, sir?
Elderly Donald.
I'm sorry. Oh, okay. What about Mr. Young? I'm sorry, what?
He refused, Your Honor.
Refused to join us?
Yep.
He obviously hasn't met me. Yes, sir, you have been charged with disorderly conduct for apparently walking around downtown, and don't say yes or no to this, walking around downtown with your pants down.
Yeah.
Don't say anything about it. Don't say anything about it. I just told you, don't say anything. All right? So, I do find probable cause for that crime. It says state misdemeanors 2 and 3. I'm not sure what additional crimes that means, unless you can fill me in. Okay.
I'm not sure.
So the bond on count 1 is $250. ROR on counts 2 and 3, because I can't find PC for what you're talking about. You want the public defender to be appointed to represent you?
Yes, brother.
Yes. All right, public defender's appointed temporarily, so I don't have an affidavit. All right, sir, thank you very much.
So now what am I leaving?
Go ahead, take your papers.
That's what I got. What was gonna happen?
All right, sir, if you'll step up, tell me your name.
Jose Villaronga.
Okay, this is a late entry, so let me just take a quick read here. Okay. Sir, you have been arrested on 3 charges: resisting an officer without violence, disorderly intoxication in a public place, causing a disturbance, and possession of marijuana of less than 20 grams. I find probable cause for each of those offenses. Would you like to have the public defender appointed to represent you in those charges? All right, I've examined your application and you do qualify for the public defender. Your bonds are set at $500 on each count. Counsel like to be heard?
Would the court be inclined to reduce some of the counts to $100? Have one count at $500 and then the following? Oh, he's eligible for PTR? I didn't. Oh, I see that. He's eligible for PTR. So can we do that on all three?
State?
Say has no objection to
All right.
PTR.
PTR it is.
Kind of.
All right, so the court will be, you bet, in recess. Do you want 45 minutes, or do you want an hour so you can actually get something to eat?
Either's fine with me.
I'm good with 45.
Anybody care?
45 minutes.
45 minutes? All right. Well, I've got to read a relatively small stack, so.
They'll reconvene at what time?
Let's make it at 1:45.
Okay.
1:45. And then we'll put the afterburners on and get through this quickly. I might actually want to go out and get something to eat. You don't want me, you do not want, let me go off the record. On the record, your name, sir?
Jordan Bernier.
All right. Mr. Bernier, you've been arrested on a charge of aggravated battery on a pregnant female. I have examined, I'm sorry, this is a warrant, so probable cause has already been found by the court. You're being held on no bond, subject to appearance before the magistrate that issued the warrant. Let's verify that. Pardon? All right. Yes, ma'am. What is your name?
Tiffany Borges.
All right. And would you like to be heard about this case?
Yes.
What would you like to tell me?
Okay, that day, let's just say that I was frustrated and I was going through a lot with my children, and I kind of escalated it more than it was supposed to be because I just wanted him to just get out of my house and leave me alone. And I had put on my statement that he pushed me, but he didn't push me. It was a way for me to get him out, and I had my mom telling me, oh, you better put him in there and stuff like that. So I was pretty much coerced to do things that I didn't want to do.
Okay. So what you're saying is that what you told the police was not true?
Yes, it didn't happen that way.
All right. Thank you. Counsel?
May I inquire?
Sure.
Would you like to have contact with Mr. Bernier?
Yes.
Are you afraid of him?
No.
Do you want him to return home?
Yes.
Okay. Your Honor, given the alleged victim's testimony, I would ask that the court order no hostile contact and that he be allowed to return home. I also looked at the warrant. It says that the bond is to be set at IA.
You're right, it does.
So,
I noticed that. Yeah. State?
Your Honor, I don't have the affidavit from the original charge. Though if the bond is to be set at IA, the state would just leave it up to the.
It does say that. It basically, the allegation is that they got in an argument, that I guess the daughter began to cry, yelling and telling him to stop. There's an argument. Tiffany went into the bathroom to call her mom. While in the bathroom, defendant came in and shoved her backwards, causing her to fall into the bathtub, bringing the shower curtain rod down at the same time. He then began to grab her legs in an attempt to pull her back out so he could get keys from her. During the altercation, Tiffany said she still had hair straightener in her hand, and it touched him in the back of the neck, causing minor burns to him, essentially. She's now saying that he didn't push her. All right. The victim's saying it didn't happen, so the victims recanted the statements. At this point, I don't think I have any choice but to ROR him. I will place a condition on the ROR that you have no hostile contact with her. So in other words, you're not allowed to fight with her. So let me just tell you right now, if he gets into a fight with you, he can go back to jail. All right?
Yes, sir.
So peace in the family, that's the requirement.
Yes, sir.
Whether the case goes forward or not will be up to the state attorney's office. You'll have to call them.
Okay, so what happens from right now? Is there anything that I have to do?
He gets out of jail. I assume that this assistant state attorney here will make notes in the file that you have recanted your testimony, and I don't know what they'll do, but you may want to contact the state attorney's office to make sure.
Okay, is there like a bond or I mean, I don't know how ROR works.
He's released on his own recognizance. He gets out on the promise to come back.
Okay,
All right?
no problem.
You appointed?
I'm not sure it's necessary at this point.
Okay.
All right, next case. Your name, sir?
Eric Fernandez.
Okay, so you've been arrested on charges of false imprisonment and battery. I find probable cause exists as to both cases. Would you like the public defender appointed?
Yes, please.
All right, I find you do qualify. So the public defender is appointed. Don't see anybody in the box, so I guess we don't have anybody here. Present, no bond. Counsel, you want to be heard?
Yes, Your Honor. Mr. Fernandez has no criminal history according to the IA base sheet, so we'd ask that he be released on his own recognizance or set a low reasonable bond if the court's not inclined to ROR him.
Well, State?
The state would have no objection to setting a bond in this case, and then all the appropriate conditions.
All right. All right, I'm going to set a bond. Well, you're going to have to find another place to live until this case is over. Do you have the ability to do that?
Yes, I do.
All right. Very good. I'm going to set a bond of $1,500 on count 1 and $500 on count 2. The special condition is that you have to maintain a separate residence from the victim in this case. You may not have any contact with her of any kind. That means you cannot call, text, phone, email, reach out through social media, Snapchat, try to get her attention on Facebook. You can't try to get in touch with her in any way, period. And you cannot have anyone else do it. So you can't, even slightly infer to your best friend, your brother, your mother, anybody, to call her and get her to drop the charges. You cannot communicate with her at all. The only person that can communicate with her is your lawyer. You understand?
Yes, sir.
All right?
Your Honor, though this case doesn't involve specifically a firearm, based on the affidavit, the state would request a no weapons condition.
That's granted. So you're not allowed to own or possess any weapons during the period while this case is pending. If you have any, you have to turn them over to the sheriff's office for safekeeping.
Me. I just wanted to ask, what's considered a weapon? A knife, things
No,
of that nature?
A firearm.
A firearm?
Yeah, I'm sorry if I said weapon. I meant firearm. All right. Your name, sir?
Good evening, Your Honor.
What's your name?
Daniel Gilmore.
All right, Mr. Gilmore, you have been charged with two crimes. One is battery by strangulation as an act of dating violence. The other is battery as an act of dating violence. I do not find probable cause for battery by strangulation based on what's in the four corners of the affidavit, but I do find probable cause for the crime of battery. Let me just take a quick look here. Right. And give us your name, please.
My name is Kelly Blanton.
All right. And you're the alleged victim in this case?
Yes.
Okay. What would you like to say?
He's not guilty. There was nothing that happened. The cops were called because of arguing and yelling. There was nothing aggressive that happened.
Okay. All right. Yeah, the reason I did not find the battery by strangulation is the only evidence of it was the observation by officers of some marks on her neck. There's no testimony. Sorry?
Yeah, I agree. I was just gonna say no restricted airway. You're good.
Well, if you agree with me, that's even better. As far as there is probable cause for the dating violence, at least based on what we have, But ultimately, what happens with this case is up to the state attorney's office. But do you have any concerns about your safety being with Mr. Gilmore?
No, not at all.
Okay. Well, I'm gonna ROR you. I'm gonna release you on your own recognizance. The only condition is you cannot have hostile contact with her. So if you're in a place and an argument starts, you're the one who has to leave. Okay? So in other words, if your neighbor hears a fight between the two of you, you're going back to jail, no matter who started it. Okay?
Understood.
You understand that?
Yes.
Okay, very well. Thank you. Sir,
Good afternoon.
your name?
Len Harris.
Mr. Harris, you have been charged with 2 offenses, tampering with a witness to hinder communication with law enforcement and battery as an act of domestic violence. Let me just remember which one this is. Right. All right, what is your name, ma'am?
Sandra Knighton.
All right, we'll get with you in just a second. Sir, would you like to have the public defender appointed to represent you?
Yes, sir.
Okay, well, you do not qualify for the public defender, so I can't appoint, you make too much money, you haven't made enough money to get your own attorney, so I can't appoint the public defender to represent you, at least not at this time. What would you like to tell me? What is your name, first of all?
My name is Sandra Knighton.
Okay.
Len and I have been together for 8 years, and he has never active violence against me. I feel like we had a very heated situation. He's not a violent person. I don't feel like my life is in danger, and I would really like to see if there's any way that I could drop the charges.
Well, as far as dropping the charges goes, that you would have to communicate with the state attorney's office about. Based on the evidence that, the statement that you gave to the police, you told the police that he grabbed you by your hair and arms, dragging you out of bed, that you tried to grab something to prevent, him from dragging you, dragged you into the hallway, the living room, that you tried to grab the house phone to dial 911, that he then basically threw you out of the house, and apparently your phone did show someone tried to call 911 but called 912. Did those things happen?
Yes.
They did. Okay. Well, I'm whether the case goes forward or not is up to the state attorney's office.
Yes.
So you'll have to talk to them about that. Okay? So as far as this case goes, probable cause does exist. The case, you were arrested on a no bond, but that, I do need to set a bond for you. State, do you have an input on what the bond should be?
No, Your Honor. Just reasonable.
Not gonna help me at all, huh?
Okay, sir.
Yes.
I have no criminal history and I qualify for pretrial release or ROR.
Okay. Well, you may. Does she qualify for trial release?
He does qualify, Your
All
Honor.
right.
Your Honor,
Yes.
I don't feel like my life is in danger. I do feel like this was a very heated situation, and I've been with this man for 8 years, and I really feel like he doesn't deserve this. I feel like this is a lesson learned,
Okay.
and I do not feel like I'm in danger at all.
State, do you have any questions for the witness?
You said that you've been with him for how long?
Years.
8 years? And has anything like this ever happened before?
I mean, we've had arguments. He has never put his hands on me, ever. He's never made me feel uncomfortable in our household, ever.
Live together?
Yes. We've been together since college.
And on this incident, you did try to call the police using your phone?
Yes, because I was just trying to get them to basically settle down the argument so I can get my things and leave. I didn't want it to go any further as him getting arrested or him making it seem like he was trapping me. I just wanted to leave and get my things, and I felt like if they came and they just basically broke up the argument, I would be able to get my things and leave, and we would be able to handle it. but we've never had a situation where he was hitting me and making me feel like I was trapped.
Okay. Sir, you have the right to ask her questions in cross-examination on these issues. Do you have any questions for her? Counsel, I'm sorry, but you cannot advise him. You're not his lawyer.
As a friend of the court?
No,
Usually at initial appearance, you can as a friend of the court.
no. I'm sorry, you're not his lawyer. You can't give him legal advice. So, do you have any questions for her?
Yes, I want to know if I would be able back into the home. The house is actually in my name. Everything is in my name. I'm allowing her to live in the household with me.
The question, ma'am, is, are you, I think your question is, are you okay with him coming back in the house and living in the house?
Yes,
Okay. With you?
yes.
Okay, I think that was your question, right?
Yes, sir.
Okay, any other questions you want to ask her?
No, not right now, no, sir.
Anything you want to ask her about the events or anything that she said?
No, sir.
All right. Okay, anything else, State?
The state is still going to ask for a no contact order just based on the fact that based on the affidavit and the statements from the victim, she was hoping to leave the residence. They were looking for, or she at least was looking for the police to intercept, so.
Yeah. Do you have another place to stay?
I can, if that would be better on his behalf. That's not a problem, but
I would be more comfortable until a final decision is made if you two are not living together. And it sounds like you were leaving anyway. So I'm going to set a bond in this matter, of, let's see, how many counts am I looking at? I'm going to set $500 bond on each count, so it's $1,000. And the condition is that you must maintain separate residences. So that means one of you has to not live there. Whether it's you or her is up to the two of you to figure out. Yes?
Well, we're both here for college. Neither one of us have family in this area, so we came here together with no family here.
Well, it sounds like she's got someplace else that she can live. That's what she said.
Okay.
So if she's offering to move out, that's fine, but you cannot live together.
Yes, sir.
Not until this is finally resolved.
Yes, sir.
Okay, because based on what she's told me, there was an act of domestic violence here. Don't answer yes or no because you incriminate yourself. But it does seem like there was an act of domestic violence here. It may have been a one-time thing, but it's still serious. So, there's been plenty of people that have, there have been cases when people have been killed on the second time. I don't know that this would happen here. I'm not saying it would, but that's always the concern. So, that's the bond I've set. You're not to live together. I'm not going to put in no contact order because you say you don't want it, right? Okay? So just don't live together. Yes?
He does meet the PTR criteria too, Your Honor, if you want to give the PTR.
Would you prefer to pay a cash bond or just get PTR, which means you don't have to pay any money, but you got to be under supervision?
And what are the supervision consist?
Visit. You have to go into offices and they let you know everything.
Well, I travel a lot. I drive trucks and also I'm a longshoreman, so I do a lot of traveling for work.
Okay, well, then
so
you're
I'll do the
better off
bond.
just to have
I'll do the bond. Correct.
Okay, so your bond's $1,000 total. Your only condition is that you cannot live together.
Yes, sir.
All right?
A no hostile contact order?
Good point. And a no hostile contact order. That means you can contact each other, but you can't fight
Yes, sir.
for any reason.
Okay.
And just understand that if you start getting into a fight, you're the only one that's going to go to jail for it. She's not.
Yes, sir.
All right? Okay. Thank you, ma'am. All right, what's your name, sir?
Jose Ortiz.
All right, sir, you have been charged in this case with tampering with a witness to hinder communication with law enforcement and domestic violence battery. I've examined the affidavit and I do find probable cause. Would you like to have the public defender appointed to represent you?
Yes.
All right, you do qualify for the appointment of the public defender, so I will appoint them in this case. I've got two. There's two case numbers here, but I only see one arrest affidavit. Oh, I'm sorry. Oh, it looks just like a case number. All right. So the public defender will be appointed to represent you in this case. Presently, You're being held on no bond. Anyone have you heard on that?
He has no criminal convictions. He qualifies for pretrial release. We'd ask for straight pretrial release.
State?
The state has no objection to pretrial release with conditions of maintaining separate residences with no contact.
Your Honor, he has no alternative address, and also the alleged victim is not here. So he does qualify for pretrial, but the alleged victim isn't here, and he has no address to go to for pretrial. We have to verify an address and get that for pretrial to work.
All right.
He just told me he has another address that he could provide, an alternative address.
All right. So how do we work that?
We do bond or pretrial release if qualifies.
Pretrial release if qualified.
Yeah,
Okay.
And so if you could set bond for him and then pretrial release if qualified.
Oh, I see. I see. Okay.
We'll try to get that done.
So I'm going to set bond of $500 on each count and pretrial release if qualified. That means you can get out today if you come up with the bond, or once you get an address set in place.
I do have an address.
Okay, well, that they got to verify it.
Okay.
Okay, the other thing is, you have to maintain a separate residence from the victim, and you cannot have any contact with the victim. Can't call, can't text, can't reach out on social media, and you can't have anybody else do it either.
Okay.
All right? Okay. There we go. If qualified.
And with bond.
Wait, no,
Well,
I
it's
thought it was the
bond
alternative.
or pretrial release if qualified.
Okay.
$1,000 total.
Yeah, thank you, Your Honor.
That's what I heard.
What's your name, sir?
Roberto Ramos Santiago.
All right, sir. You have been charged with the offense of battery on a person 65 years of age or older. I do find probable cause for that offense. Would you like to have the public defender appointed to represent you?
Yeah.
All right. I've looked at your affidavit. You do qualify. Public defender will be appointed. Your bond is presently set at none. You are entitled to have a bond set in this case. I am considering a bond in the amount of $1,000. Would counsel like to be heard on that?
Yes,
Either
Your
counsel?
Honor. He has 0 criminal convictions and 0 failures to appear. We ask he be released on his own recognizance.
State?
Your Honor, based on the facts in the affidavit, as well as, based on the facts, the state would ask for no contact, though it appears that, or I'm not sure if they're living together, but the state would request a monetary bond.
Right. Bond will be $1,000 on the single count, and you're going to have to maintain a separate residence from the victim if you two live together, and you can't have any contact with the victim. You understand?
Okay, I understand.
Okay. Thank you. There you go. Sir, your name?
Adam Swain.
All right, Mr. Swain, you have been arrested on 2 charges, battery by strangulation as an act of domestic violence and battery as an act of domestic violence. I found probable cause on both of these cases. You do not qualify for the public defender, so I won't be able to appoint them to represent you. You'll have to hire your own lawyer if you want to. The bond that's presently set on this matter is 0, but you are entitled to a monetary bond. State want to be heard on the amount of bond?
Your Honor, state would request a $1,000 bond on each count.
As a friend of the court, I noticed he qualifies for pretrial release. As a friend of the court, I realize, looking, he qualifies.
Well, I'm
for
glad you
pretrial
told me.
release.
That's good. Does he qualify for pretrial release?
Your Honor, with no alleged victim here and no alternative address, he doesn't meet the criteria for pretrial right now because of those 2 things.
Okay. I'm going to set a bond of $1,000 on each count, or pretrial release if you qualify. So that means you're going to have to give them an alternative place that you're living that they can verify. When you get out, you are not to have any contact of any kind with the victim in this case. Means nothing. No phones, texts, Facebook posts, nothing. You understand?
Yes, sir.
All right. There you go. What's your name, sir?
Carl Michael Allen.
Mr. Allen, you have been charged with battery as an act of dating violence. I have examined the four corners of this affidavit. I find probable cause. Would you like the public defender appointed?
Yes, sir.
All right, I'm going to appoint the public defender to represent you. Based on what I've read, I'm inclined to release the defendant on ROR based on the facts I've read. State, you have anything you want to say?
Yes, Your Honor. If the court is inclined to ROR, the state would still request conditions to be set of no contact.
Well, apparently from what I've read, this is a case in which the alleged victim wanted nothing to do with prosecution or with even arrest. So I'm not going to put any conditions on it because it doesn't appear that they wanted any.
Yes, sir.
Okay. There you are. ROR, yeah.
He said no conditions. ROR, no conditions.
But I do find probable cause, but ROR anyway. No. Nope. All right.
I'm just letting her know I spoke to DCF. So
Sure.
Okay.
What is your name?
Hind Kosan.
I'm sorry, what?
Hind Kosan. Hind.
Are you Miss Hind?
Hind, yeah.
Hind, I'm sorry, Hind.
That's okay.
I couldn't quite hear you with the printer.
Sorry about that. I
You've
speak
been
soft.
charged with battery as an incident of domestic violence. I've read the affidavit and I find probable cause. You have filled out a form requesting the public defender. Is it your desire to have the public defender appointed? Do you want
He's asking if you
her?
want an attorney. Do you want an attorney is what he's asking. Yes, he's asking if you want an attorney right now to represent you. That's what he's asking.
In other words, do you want an attorney to represent you today and then throughout the history of this case? Or do you want to hire your own lawyer?
Yeah, I will hire my own lawyer. I will hire my own lawyer.
Okay, so you don't want the public defender right now? Okay, tell you what, let's do. Why don't I appoint the public defender just for today? Okay? So she can speak for you today, and then you can hire your own lawyer for the rest of the case.
Okay.
All right, so you're appointed temporarily, just for today. All right, presently you're held on no bond. Obviously, I have to set a bond state. You have a suggestion?
Yes, Your Honor. The state would suggest $1,000 bond.
All right.
May I be heard?
Yes, you may.
I spoke with Amy Hanks with DCF. She reached out to me. She informed me the alleged victim's not coming. He's currently at home with the children. He's a truck driver and he's not going to be in the home. So we would ask if, since the court has to order no contact since he's not here, that you impose a maintain separate residence condition, and allow third-party contact with children because they're her children. There is a safety plan in place, so they can have third-party contact through DCF. And she qualifies for patrol release. She has no convictions. But DCF told me that the victim is going to be leaving the house.
Yes, she has no alternative address, so that would be the only thing I see.
Okay.
With him not.
Well, I'm going to order pretrial release, but you have to maintain separate residences, so he's going to have to leave. Yes?
Could you do a bond or pretrial release if qualifies with this one also? Because if we contact him and and he doesn't want to get out of that house, we don't have a house for her, and she has given us no alternative address. Do you have an alternative address?
It's for the kids. There's 3 children at home, and DCF's involved. So that's all.
But we have to verify. So that's
All right, so let's make it $1,000 bond or PTR if qualified.
Thank you. Just
Well,
to make
basically
sure
what that means is as long as he is going to be leaving the house, so you can live there on the kids without him, then you can get on what's called pretrial release, which means you don't have to put any money up and you just got to report in. If he doesn't want to leave the house, then you can get out by posting a $1,000 bond, but you got to find someplace else to live. Okay?
And for how long?
Until the case is resolved one way or the other.
Just to be clear, you're ordering maintain separate resident, not do not return.
Maintain separate residence, yes.
Okay.
Till it's closed?
Yes, or until we modify it.
Yeah. No, I'm not, yeah, no contact with the victim.
Covers all the bases, so she's not stuck in here with the PTR, because we didn't have a place for her to go, so
Right.
that's better for her.
Okay. All right.
We'll do our best to get her on.
All right, ma'am, I'm going to have to ask you to, you can chat with the lawyer later, okay? Thanks. Yes, sir, what's your name?
Elijah DeLeon.
Mr. Leon, you have been arrested on a charge of battery as an act of domestic violence. I do find probable cause in that case. Would you like to have the public defender appointed to represent you?
Yes, sir.
Public defender is appointed. Your bond right now is no bond. Do we have anybody here? No, to testify about the case? All right. Anything from counsel?
Your Honor, he has no criminal history, and he qualifies for pretrial release. An alternative address was provided, so we'd ask that he be released on pretrial release.
State?
I do see that an alternative address was provided. The state wouldn't object to PTR with a no contact order, no return.
All right, so PTR will be granted. You are not allowed to have any contact with the victim during the pendency of this case, and you have to maintain a separate residence from where the victim lives.
Your Honor, is there also a no return to where the victim will be staying?
Yes.
If you order a no return, can you one-time
Yes.
return?
You may return to the residence.
That's my apartment. She's on a lease, but I pay everything. I'm the breadwinner. Without
There's
me
nothing we can do about that. You just do one-time reimbursement, we'll deal with it later.
Yeah, you can go back one time to get your personal belongings in the presence of law enforcement officers. Okay? All right. Thank you.
Yes, until it's modified.
All right, sir, what is your name?
Alan Duffy.
All right, Mr. Duffy, I read the arrest affidavit. You've been arrested on a charge of battery as an act of domestic violence. I do find probable cause exists based upon the four corners of the affidavit. You do not qualify for a public defender, so I won't ask you about that. Presently, you're being held on no bond, but you are entitled to release. State, do you want to be heard on that? Oh, I'm sorry. We have somebody here to speak. Would you tell me your name?
Marion Elizabeth Hislop.
Okay. Would you please raise your right hand? You solemnly swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right. What would you like to tell me?
I want all charges dropped. I was so drunk, I don't even remember the incident.
Yeah.
I've been with him 11 years, and he would never, ever hurt me.
Okay. I cannot drop the charges. The state attorney's office does. You'd have to talk to them. But what I can do is release him on his own recognizance, which I was planning to do based on what I read. So he'll get out today. The only condition of your release, yes.
Well, he lives out of the country.
I know. Oh, yeah. So you're released on your own recognizance, which means you will be able to get out of jail. The only condition is no hostile contact with her. In other words, you can't get into a fight with her. All right? Whether the case gets prosecuted or not will be up to the state attorney's office. Based on what I read, I highly, highly doubt that it will, unless the world has gone totally mad. He'll be released, and he can't fight with you, but other than that, you can do what you want. Now, are you from outside the country?
From Scotland.
From Scotland? I mean, if you choose to return to Scotland and the state chooses to file the case, you know, they may issue a warrant for your arrest, but like I said, I can't imagine that's going to happen. But so, good luck. Yeah, and I'm not telling you you can't leave. Let me put it that way.
Yeah. Will I be okay to come back on vacation at some point? Will it be allowed?
Well, yes, in bizarro world, if you were to go back to Scotland today and they were to decide to file an information in this case, yes, there would be an arrest warrant out for you in case you ever came back. But that's bizarro world. I can't imagine that's going to happen. Okay? Enjoy the rest of your vacation. You got to see a part of Orlando people rarely do. All right, sir, what is your name?
Michael Gonzalez, sir.
Okay, I'm going to off the record for a second. Anyway, back on the record after my statement. Sir, you've been charged with battery as an act of domestic violence. I've read the arrest affidavit. I do find probable cause. You have a request here for the public defender to be appointed. You do qualify, so I will appoint the public defender at this time. I don't see anybody waiting to chat with us, so your bond is prettily set. No bond. Would you like to be heard on bond, counsel?
Yes, Your Honor. It doesn't look like he has Florida convictions, or it's not really clear, but he does have some convictions out of state, I think, and they're mostly misdemeanors. So we'd ask that you set a bond of $500.
All right.
He doesn't qualify for pretrial release, but I don't know why.
State?
The state would request $1,000 bond in this case.
Oh, let's see.
Face sheet, Your Honor, if you would like to see it.
Yes.
And was out of Wisconsin, I believe.
Oh, yeah, but open.
Cool.
Yes.
All right. Oh, okay, yeah. Virtually very little. I'm just going to set a $500 bond in this case. And the condition is no hostile contact with the victim. So in other words, yes, sir.
Is that $500 or is that 10% of $500? I've never.
If you can get a bond, bondsman will usually put up the bond for a 10% premium. So usually you pay them $50 and they'll put up the bond.
They'll do it for $100.
But I'm not totally sure. I've never been arrested.
Cash, or you can do $100 on that $500. So if you can come up with $100, a bondsman will help you.
All right.
I don't have any phone or anything here.
Your name, sir?
Hello, Your Honor. My name is Christian Hernandez.
All right, sir, you've been arrested on a charge of battery as an act of domestic violence. I find probable cause to indicate that that crime was committed. You have an application for appointment of the public defender, and that will be granted. The public defender will be appointed. Bond?
Your Honor, he has
Oh,
no...
I'm sorry, we have someone here.
Oh, I'm sorry, I didn't see.
I'm sorry, thank you. Could you tell me your name?
Jildarius Hernandez Nieves.
Okay, would you please raise your right hand? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, what would you like to tell me?
This wasn't supposed to happen. When I got home, I provoked him and told him push me. So he pushed me, but that was the only contact. When we were outside arguing, somebody called the cops, and the cops, Christian told them that he pushed me, but I let him know that was something that I provoked and told him to, and that I don't want to press charges. Everything is fine, and then they took him.
All right.
May I inquire?
Sure.
Are you afraid of Mr. Hernandez?
Absolutely not.
Do you want him to come back home?
Yes, please.
Would you like contact?
Yes, please.
Is there any history?
He has no criminal history on it, according to the face sheet I have.
Okay. State, anything contrary to that?
No, I see that he has no history.
Okay. Any position on release?
The state would ask for, at the minimum, a no hostile contact order.
All right. Here's a suggestion. Don't provoke people to be violent in front of your kids. Doesn't do them any good.
That wasn't in front of my child. That was in a spare room. They were
sorry.
not present when that happened.
Okay. All right, well, good. So he's going to be released on his own recognizance. The only condition is no hostile contact. In other words, you cannot get into a fight with her as long as this case is pending. I suggest you not tell him to push you.
Yes, sir.
Not a good idea.
Yes,
All
sir.
right. And as far as the charges go, you have to talk to the state attorney's office about that.
Okay.
Okay?
Thank you.
Thank you, Your Honor.
Thank you. Okay. Please tell me your name.
Tamara Hunt.
Okay. You were arrested on a charge of battery as an act of domestic violence. I've read the arrest affidavit. I do find probable cause for that charge. You have requested the appointment of the public defender. You do qualify, so the public defender will be appointed. Bond?
Your Honor, there's a victim here, so I want to let him testify before I make my argument.
Oh, I'm sorry. I always forget to look over there. Hi, what is your name?
My name's Austin Hunt.
Okay, raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay, you probably don't have to lean down. We'll tell you if you do.
Okay, yes,
Just
sir.
be comfortable. You're kind of tall, so that's unusual. What do you want to tell us?
I just came down from Michigan on vacation to meet with my wife and son, and just things got hostile, you know.
Is that your son out there?
Huh?
Is that your son out there?
No, my son's with her mother.
I saw a boy out there with some
No.
smooth dance moves. I thought that might have been your son. So what do you want us to do?
Honestly,
Yeah.
I just want you guys to just drop everything and just, you know, put something in order where, you know, she don't contact my job. That's it. That's all I want. I don't want no problems on that end. I just want her to be able to just move on with her life and,
Okay.
you know.
So the condition you would like is that she not contact your work?
Yes,
And what is that? Where's that?
in Michigan.
In Michigan. Okay. How has she been contacting your work? She been calling or something?
I'm in the Army, stationed there. So she's just been contacting them, using the channels that way, and I just don't want her to provoke and put unnecessary
Right.
stuff like that, because I know how people get. But I just want to move on with my life. I don't.
Well, I can't like tell her she can't call the military if it's a legitimate reason. So that's the only reason I'm counsel.
I was just going to suggest then a no contact order for him, and that would then include calling the military for purposes of reaching him.
Well, they have to have contact because they have kids together, a child together. So that's not practical.
May I inquire?
Sure.
Do you want contact with Ms. Hunt?
I'll contact her until she gets help.
Wait, I'm sorry.
Only way I will contact her unless she gets help.
So do you want contact with her right now?
I mean, of course, we share a child. Of course.
Okay. Are you afraid of her?
No, not really.
Okay, do you want her to come back home?
She don't live with me. She moved. She moved from Michigan to here.
They're not together.
Okay.
Right.
She left and moved here.
Okay. Here's what we're going to do. The condition of release is going to be that you can only contact him in reference to your son and for no other purpose, and that contact has to be non-hostile.
Can I say something, Your Honor?
If you want to, sure, but you might want to check with her before you do. But go ahead.
Well, I was just going to say that
I am not the abuser, but I left Michigan to get away from the abuse. I moved here to start a whole new life, and I went on vacation, and he wanted to come on my vacation with my son, and broke everything that I own. And so I don't know why he's playing the victim when he's the one with all the mental conditions.
Okay.
I just simply, he came, I asked him not to come, he came, and then he broke my phone, and I tried to get my phone from him, and he started lying, and even the witness in the statement told them that he put his hands on me. I didn't put my hands on him.
Well, here's what we're going to do.
Sir,
Yeah.
I apologize. I apologize about that. You know what? My heart, you know what? I'm going to do the right thing right now. We've already done this one time in Michigan. We had a no contact order. She got arrested already for the same stuff. Why I say she needs help is because she needs to get psychological help. And I've already been through this one time. She's making all this stuff up. I came here. I got text messages. She went in a hotel. I came here. You know what I'm saying? I just found out she was cheating on me. That's why the event happened yesterday. I found out she was cheating on me. Okay? I got too much to lose to be putting my hands on a woman.
Okay, let me stop you right there because
Yes, sir.
clearly there's a lot of issues going on here. So what I'm going to do is I'm going to release you on your own recognizance. You're not to have any contact with him except as it relates to the children, and that must be through an app called Talking Parents. Both of you get it on your phone. That way every communication you have is recorded.
What is it called?
Talking Parents. Okay, you got that, sir?
Yes, sir.
Talking Parents. Your conversations are to be non-hostile, and so and that only applies as long as this case is around. Now, if the state does not file charges, then these rules go away. All right? So either one of you can apply in Orange County Circuit Court for what's called a domestic violence injunction. If you want to go down there, you file it, and the court will decide. That's the division I work in. They'll decide whether you guys need to have orders long-term to stay away from each other. So if you feel that you're a victim of abuse at his hands, then you can go down and get an injunction, and same thing for you.
I mean, ultimately, I don't want that. I want my family. I want my wife. I want my son. I want a family. I want everything. It's just, I'm just tired. Just the narcissistic ways. I'm just.
Well, y'all got to work that out.
Yes,
so
sir.
right now, as long as this case is in existence, no hostile contact with him and only contact about the child. And I hope you guys can work it out, but we can't do that for you. All right, sir. Thank you.
Is there a bond or anything?
No.
Can I say something to her before she leaves?
No.
Her bag's up front with her wallet and stuff. I got to catch a flight.
Okay. No, I guess not. She's already gone.
Say again?
What? I'm sorry. So some of her property is what?
Yeah, her laptop, her bags, her IDs, everything's up front in a bag. I got to catch a flight.
Well, if
So
you
somebody
put it in
needs
her
to let her
property, I'm
know.
sure it's fine.
Can he put it in her property? Can they? I don't know. Well, he's gone now, so I guess we'll never know. No hostile contact. Please. Okay. Next case. Sir, what's your name?
Andrew McMasters, Judge.
Mr. McMasters, you have been arrested on a charge of battery. Doesn't say domestic, but nope. Oh yes, it is domestic. As an act of domestic violence, I do find probable cause for that charge. Would you like to, have asked for the public defender to be appointed?
Yes, Your
So
Honor.
the PD will be appointed to represent you in this case. As far as your bond goes, your bond is set at none. And I believe the allegation here was that the victim and defendant lived together. I think that's, if I'm reading that correctly. So does the, what does PTR have on Mr. McMasters?
He does not qualify for PTR.
Does not qualify for PTR? Okay. Does he have any prior history?
Yes, Your Honor. Florida convictions, attaching tag, petty theft, FTA for possession of coke, FTA for possession of drug paraphernalia, FTA for possession of cannabis, DUI, damage to property, no juvenile convictions, Florida arrest, out-of-state convictions. He has multiple out-of-state convictions.
All right. I'm going to set the bond at $1,500. You're going to have to maintain a separate residence from the victim, and you're not to have any contact with the victim during the pendency of this case. All right. Thank you, sir. You're all done. Are you Eric Parks?
Yes, I am.
All right. You've been arrested on a charge of battery as an act of domestic violence and resisting an officer without violence. I find probable cause exists as to both. Thank you. You did not. Would you like to have the public defender appointed to represent you?
I was told I probably made too much, so
You don't qualify?
I'm gonna have to search out for a little.
All right. Well, then you'll have to hire your own attorney. You are entitled to a bond on this case. Just a minute. Let me look at this.
There's a victim here.
Oh, hello.
Hi.
I always forget to look over there. Raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
What's your name?
Corinne Parks.
All right. What would you like to tell me?
There was absolutely no domestic violence in our home last night. We've been married 28, going on 28 years. He's never laid a hand on me. He was simply helping me. I had too much to drink, and he was helping me in the house.
Well,
And-
according to this, the officer was, I guess, trying to talk to the two of you, and he was sort of pushing you in the house as you would walk toward the officer. Is that what happened?
He just wanted me to get in the house. I had too much to drink. The neighbors actually were the ones who called the cops. They thought that I needed help, I guess, because I passed out in the front yard.
All right.
But he did not hurt me in any way. He's not a violent person whatsoever.
All right. So on count one, I'm going to change ROR on count one. The victim indicates that. Do you feel you need any orders of protection?
Absolutely not.
Okay. Well, I'm gonna put in a no hostile contact order anyway. It just means you can't fight with her. Okay. Don't fight.
Sure.
You know, if she's drunk in the front yard, just leave her there.
Okay.
Or pick her up very gently.
Okay.
You know. Sorry. As far as resisting without violence, however, the officer has a right to pursue those charges. So I'm going to maintain. I'm going to set the bond on resisting without violence. Does he qualify for PTR on that charge?
He does meet PTR criteria on both the charges, Your Honor.
All right, then PTR on the resisting without violence. All right, sir.
Okay. Thank you.
Thank you, ma'am.
Does that mean it doesn't cost anything to get out?
Yes. Yes,
Okay.
exactly.
Thank you.
All right. ROR on the battery count and PTR on the other count. All right. Your name, please.
Princess Ship.
All right, Ms. Ship, you have been arrested for an act of battery that constituted an act of domestic violence. I do find probable cause exists in that case. You've requested the appointment of the public defender. You do qualify, so they will be appointed. Sir, could you tell me your name?
Richard Davis.
Okay, raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes.
All right, what would you like to tell me?
Me and Princess been dating for a year and a couple months on and off. We fight, argue all the time, and be right back together. It was one time, well, this time, like last month, we broke up, and I just been like really trying to get her back, but she have feelings for her ex before me, and I've been jealous towards that. I've been acting like a a-hole and a DICK towards her about it. And yesterday, like, I was laughing at her, and I know she felt disrespected, and that's what caused her to get angry, and that's what caused her to do what she did. I know it wasn't in her intention on doing that, because I know deep down she do still love me, and I know, she don't want to be in this predicament, and I don't want her in this predicament. I told the officers, sheriffs and OPD, because both of them was there, that I did not want to press charges, and I just want her to be home. She have a 2-year-old daughter, finna be 3 on Tuesday. I don't want her daughter to have to go through this, her mom being in jail, or, her not being able to come home to her daughter.
Okay.
That's not my intention on doing that.
You want us to release her to come back home?
Yes.
Are you in any
I
fear of her?
I don't feel threatened. I don't feel like I'm unsafe around her. We work together, and I just want her to come home. I want us to still have our friendship that we have, and I just want to be able to be in her and that baby life like I always have.
Okay. Any questions from, did I put the public defender on the shed?
I believe you did.
Okay.
I just can't remember. It all blurs together.
If I didn't, I do.
Okay.
Do you have any questions for him?
No, you asked all the questions that
Okay.
I need to ask.
State, you got any questions?
No questions from the state. We're just still requesting no hostile contact order at least.
All right. Okay, so he wants you out and back home, and I want you out and back home too, but I want you out and back home and not fighting with him. Now, we're gonna be able to do that?
Yes.
And
Okay.
Sir,
So-
I'm sorry to
Yes.
interrupt you. I was the cause of all this. She wasn't the cause. She didn't,
Well-
she just, the
That-
way
that-
that she took it out of play,
Sure.
out of order, that, she shouldn't have done that, the way that she did it. But I did provoke her to get that mad, you know what I'm saying?
Well,
And-
here's the thing, and I understand what you're saying. But no matter what somebody does, you can't go off hitting people. Just can't, unless you're defending yourself and they attack you first. You just can't be hitting people. That's the law. That's the way it is. Whether this case is pursued by the state attorney's office, you have to talk to them about later. But for right now, you're going to release ROR. The only condition is you have no hostile contact with the victim, with him. You can't fight with him. If he starts getting on you about something, if he starts provoking you, you got to get the H out of there. Because you're the only one that's going to go back to jail, not him. All right? Okay, thank you. Okay. Well, that was fun. Okay, yes, sir. What is your name?
Daniel Eubanks.
Sorry?
Daniel Eubanks.
Okay, I had a Mr. Chandler.
Refuse, Your Honor. I believe we represent him. Just let me double check. It's a failure to appear. I was going to waive his.
Oh, okay.
But I just want to make sure that we actually do represent him. I think we do, but.
Looks like failure to appear, yeah. Oh. And there's a new resisting without violence. So,
Yeah, because of the FTA.
and one new. Okay. I only have two.
I think we do represent him, so just waive his.
All right, so on those, the IA is waived on the new case, which is 19-514, the public defender is appointed, and the bond is stayed. Sir, yes, sir. You have been arrested for possession of fentanyl and possession of cannabis. I read the arrest affidavit, and I find there is probable causes to both charges. Your bond on the first charge, well, first of all, you've asked for the public defender to be appointed, is that correct? All right, we'll appoint the public defender, and your bond on possession of fentanyl is $1,000. Your bond on possession of cannabis is $100. I find probable cause as to both. Anything else from anybody? All right.
The DTR criteria, Your Honor.
He does?
Yes, Daniel Eubanks.
Yeah, okay, well,
And, Your Honor, just noting that there is history that includes similar charges, so the state was going to agree with having the bond stayed.
okay,
He just said he'd rather have a bond, so don't order PTR. Just-
okay. A condition of your bond is do not possess or use any controlled substances. Now, this is a comment I want to make to you that do not respond to this. Do not say anything. Fentanyl, that stuff is killer. Okay, you've got to get away from that stuff. That stuff will kill you dead. That's all I want to say. Go ahead. Sir, come on up. Maybe Mr. Is it Feck?
No, Amethyst Becky, she refused, Your Honor.
Refused, okay. All right. And what's your name, sir?
Alexander Lee Glover.
Alexander Glover. Mr. Glover, you are here on a new charge of trespass in a designated construction site. I do find probable cause for that offense. Would you like to have well, you've requested the public defender to be appointed. You do qualify, so I appoint the public defender to represent you. You also have 4 cases in which you are out on release. It appears that, on 18-1533, you are out. It says court order incompetent, so I assume that's having been found incompetent and released.
We represent him on all these cases, and he's been adjudicated incompetent on all of them.
The 2019-2023, however, you're on ROR, and it says incompetent, but it doesn't say that there's a court order finding incompetence.
I had it as found incompetent to proceed.
Could be, but he got ROR on that one. 2019-6002, it says a court ordered incompetent. And the same thing on 2019 MM003551A. Also, it says incompetent. State, you want to be heard?
State would request that bond on this case be given. I didn't hear if he was out on bond on it.
Well, he has one, at least, that appears to be
State would just
ROR.
request that to be revoked.
Your Honor, I just pulled all the court orders for this. It's per the case that I'll put it on the record. Palacio, P-A-O-L-E-R-C-I-O. The case site for that is 129 Southern 3rd, 1174, 50 CA 2014. Trial court erroneously held the detention of a person who's been adjudicated competent to proceed on the finding of probable cause of a new crime. The case that I cited to you.
Is that a case in which the defendant had been found incompetent in that case or in any case?
No, because it's about someone it's about this situation where they pick up new charges and they revoke, because it says the trial court erroneously held that Florida Statute 903.047 authorized the detention of an incompetent defendant upon the court's finding of probable cause for a new crime. So you can't you could probably still set a bond in this case, but you can't revoke the bond in those other cases. Because we'll just file a motion and put him back on conditional release if you.
Well, but the one case I'm not sure is on conditional release. I mean, do you have a court order finding him incompetent in 2019-2023?
Let me pull it up, because I saw it on the other ones. Is that the felony?
That's the petty theft, 2 prior convictions.
Let me pull it up.
At least in our system, Judge, I'd see a competency status hearing, but no finding yet. I believe there's one evaluation.
I have the order. I could approach.
Sure, please do.
Defendant found incompetent to proceed. May I approach?
Sure.
Court order in that case.
Okay. 2020. Right one, yeah. right.
There you go.
All right, so the court will take no action on the existing cases, but the court will stay the bond at $1,000 on the new case.
Thank you, Your Honor.
Okay. Your name, sir?
Kelly Gooden.
Mr. Gooden, you are arrested on 3 charges. One is burglary of a structure. Second is possession of drug paraphernalia. Third is trespass on a designated construction site. I do not find probable cause on burglary of a structure because I don't find any reference in the affidavit to there being a structure. It just refers to it as a construction site, but it doesn't say that there's a structure on it. Would the state like 24 hours to supplement?
Yes, please, Your Honor.
All right. So what we're going to do is we're going to give the state a chance to supplement that based on new information. Now, you also are out on bond right now on another case. That's 2019 CF 3794, burglary of a conveyance, possession of burglary tools, petty theft, possession of drug paraphernalia, and trespass in an occupied, conveyance. Go ahead.
Sure, you're done. No information's been filed in that case. It's been more than 33 days. He was arrested for that offense on March 17th of this year.
Okay. I'm going to revoke ROR on that case and stay the bond. Well, we'll bring this back tomorrow in front of Judge Wilson in case the state can supplement that burglary.
So are you revoking on the old case now?
I'm revoking on the old case,
Okay.
yes.
And there was PC for counts 2 and 3?
PC was found for counts 2 and 3. The problem with count 1 is there's no reference in there to a structure.
Sure.
All right, thank you. Your name, sir?
Isaac Leon Grayson.
Mr. Grayson, you have been arrested on a charge of driving while license suspended, 2 prior convictions. I do find probable cause exists for that offense. Did you request the public defender to be appointed?
Yes, sir. I did, yes.
You did, all right, and you do qualify. Public defender will be appointed. You have a bond in that case of $2,500. You also, according to this, were out on cash bond or surety bond on another driving while license suspended case in 19 CT 3917. Either counsel like to be heard?
State would just ask that bond be revoked in the other case.
I was going to ask that you take no action, but you're going to do what you're going to do.
Yeah, I got to revoke your bond on that one because you are alleged to have committed, don't say anything, you're alleged to have committed the same crime that you were on bond for committing. Again, don't say anything about whether you did or not because you might hurt yourself, but I'm going to revoke the bond on that one and stay the bond on the new case. Okay. Sir.
Lane Griffith.
Mr. Griffith, we're arrested on a couple of things here. We've got a violation of probation warrant out of Lake County. You're being held in no bond on that until such time as you see the judge over there. You're arrested in Orange County on possession of heroin, possession of methamphetamine, and possession of drug paraphernalia. I do find probable cause for all of those cases. Would you like the public defender appointed to represent you in the new cases?
Yes.
All right, public defender will be appointed. You're being held on no bond on the Lake County case, and that will be stayed. Your bond on the new Orange County cases is $1,000 on the heroin case, $150 on the meth case, and $100 on the drug paraphernalia case. Thank you, sir. You'll be all the bonds are stayed on the new cases. Your name, sir?
Benjamin Hayes.
All right, Mr. Haynes, you have been charged with 4 counts: possession of cocaine, possession of alprazolam, attempted destruction of evidence, and possession of cannabis under 20 grams. I find probable cause as to each crime. Would you like the public defender appointed? You want the public defender appointed?
Yes, sir.
Appoint the public defender. Your bonds are $1,000 on count 1, $1,000 on count 2, and $500 each on the next 2 counts. Anything else from council? Hearing nothing. Thank you, sir. Bonds are stayed.
We'll do a motion for a bond, okay? We'll do a motion for a bond. He's not gonna do it because you're FTAs.
All right, sir. Please tell me your name.
Jeffrey Halfacre.
Okay. Mr. Halfacre, you have been arrested on, is this a VOP?
Yeah, I don't get that, sir. I'm not on probation.
Hold on. Oh, it's a warrant, yeah, okay, I'm sorry. You were arrested on a warrant charging you with failure to update your driver's license as a sexual offender. Probable cause has already been found in that case. No bond was initially placed on that matter, but you are entitled to a bond. Would you like to have the public defender appointed to represent you?
Yes, please.
All right, and the court will appoint the public defender to represent you. I don't see in here an authorization to address bond at IAs, unless I'm missing something. Hold on, I'm asking counsel, sorry.
Looking at the warrant.
Warrant says no bond, but it doesn't have,
We didn't put the note. Normally they write like can be modified at IA, but on this offense he's entitled to a bond, so I would ask for a reasonable bond to be set.
well, I think,
It doesn't say no modification, it's silent.
true.
And since it's not punishable by life offense or capital.
Yeah, I think he's entitled to a bond. Suggestions?
He has no failures to appear. He has some criminal history, but, so we asked for a $1,000 bond.
State?
Your Honor, based on the history and the nature of the charge, the state would ask for at least a $2,000 bond.
How much?
At least a $2,000 bond.
Okay, court will set $2,000 bond. Okay. Don't tell me we've run out.
Oh, no.
I still got a whole pile? Holy mo, come on, folks. Oh, this is H up here. Your name, sir?
James Edward Hall.
Mr. Hall, you have been arrested on failure to appear on 2 matters. Your bond is set at none until you see the judge involved in the case. Do I need to appoint the public defender, or are you guys already in this?
I think we're already on the case, but I will double check. Oh, you're.
Well, you know, for speed's sake, I'm just going to appoint you. If you're not, then if you are, it's repetitious. If not, so appoint the public defender. Thank you, sir. Mr. Jimenez?
Bonded, Your Honor.
Pardon?
Bonded.
Oh, bonded. Oh, okay. Well, that's good news. Okay, your name?
Porter Jones.
Mr. Jones, you have been arrested on charges of possession of cannabis with intent to sell, possession of cannabis under 20 grams, and possession of drug paraphernalia with intent to sell. I don't think there is such a thing. There isn't an intent to sell in paraphernalia, is there?
I've never seen that.
Nah, doesn't matter. I do find probable cause for those offenses, and your bonds are set at $1,000, $150, and $150. You've applied to have the public defender appointed. You qualify, so the public defender will be appointed. Anything from council?
No, Your Honor.
Bonds will be stayed as they are. Would you please tell us your name?
Michelle of Cap.
All right, you have been arrested on charges of possession of cocaine and 2 counts of possession of drug paraphernalia. I do find probable cause for those charges. Would you like the public defender appointed to represent you?
Yes.
Okay, I don't have an affidavit, so we'll appoint the public defender temporarily until you have arraignment and do a proper affidavit. You are presently on pretrial diversion on another case, so that's up to the state attorney's office to decide what to do about that one. So, thank you. That's I don't know if I said I said what your bonds are again. Thank you very much. That's it.
I don't think you set the bonds in this case.
I thought they already
might have
have.
missed it, but
Yeah, the bonds are 1,000, 500, and 500. If I didn't say that, I think that they're staying.
There's no action on the auto bond, Your Honor?
There's no action, no. No, it's on pretrial diversion, so it's up to the state to decide to reclaim the case. All right, sir, step up. I know you don't know what Flock of Seagulls was, but that was a popular hairdo about 20 years ago. All right. Sir, you've been arrested on a number of...
Brendan Little bonded, this is Miguel Martinez.
Well, that's Brendan, okay, Brendan Little bonded. Okay, well, Brendan Little doesn't have the cool hair then. Your name, sir?
Miguel Martinez.
Mr. Martinez, oh, you've been, that's not cool. You've been arrested on 4 charges, trafficking in methamphetamine, under 28 grams or over 20? I can't even figure that out. Possession of methamphetamine with intent to sell, possession of drug paraphernalia with intent to sell, and possession of cannabis. I do find probable cause for all of those offenses. You have an application to appoint a public defender, which is granted. You qualify, they're appointed. Anything else from either counsel?
he qualifies for pretrial release. He has no criminal history. We ask he be released on straight pretrial release.
No, the court will stay the bonds as is until the trial court has a chance to get more information. Thank you, sir. Your name, sir? Mr. McClendon, I have here 2 matters involving you. The first is aggravated assault with a firearm. I have looked at your arrest affidavit, and I do find probable cause for that. I also have an arrest affidavit with 6 counts: possession of cocaine with intent to sell, possession of cannabis with intent to sell, possession of cannabis under 20 grams. Or is it over 20 grams? It's under, yeah. Grand theft, 3rd degree of a firearm, possession of drug paraphernalia, and possession of a concealed weapon or firearm by a convicted felon. I find probable cause for all those charges as well. You've applied for the public defender to be appointed. You do qualify, so the court will appoint the public defender. Your bonds in these cases are as follows: $15,000 on purchase of cocaine with intent to sell, $150 on possession of cannabis with intent to sell, $150 on possession of cannabis and grand theft, $100 each on possession of drug paraphernalia and possession by a convicted felon. On the aggravated assault charge, no bond is presently set. Would any counsel like to be heard on that?
Yes, Your Honor. It's a non-punishable by life for capital offense. He's entitled to a bond. Since he already has one bond of $15,000, we just ask that you set that one at $100.
Counsel?
Your Honor, the state would request on the aggravated assault with a firearm at least a $1,500 bond.
I'm going to set a $1,500 bond on the aggravated assault charge. And thank you very much.
We can always get you a reduction.
Okay. Your name?
Sequita Pugh.
All right, Ms. Pugh, you have been arrested on a new charge of retail theft under $300. Where's that over? You know, I can never remember what that little arrow means. Huh? Under. I thought it's under the other way. Sorry. I do find probable cause to find that you committed that offense. Your bond is set at $1,000 in that case. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. I don't have an affidavit, so I will temporarily appoint a public defender for purposes of this hearing. You also are on bond on charges of armed robbery, grand theft, resisting a merchant, ag battery with a motor vehicle, ag battery with a weapon in 2018 CF 9224. You are on bond on grand theft third degree in 2018 CF 3311 out of Osceola County. Anybody want to be heard?
She's just trying to tell me that some of the counts on that case were dropped, and I'm telling her that some of the counts are here, so.
Right.
State would ask that bonds be revoked.
Okay. Those are filed cases, I trust, since 2018?
I did check, they are filed.
Okay. The court's going to revoke bond on the two old cases, and the bond on the retail theft will be stayed. What that says, ma'am, is that whatever charges were actually filed, whatever bonds you made are revoked. So you're going to have to go in front of the judge on those old cases with no bond unless that judge changes the bond. All right? Thank you. Yes, ma'am. Okay. So, what's your name, ma'am?
Pauline Romero.
Okay. You've been arrested on a charge of driving while license revoked as an habitual offender. I've looked at the arrest affidavit. I do find probable cause for that offense. You have applied for the public defender to be appointed, and you do qualify, so the public defender is hereby appointed. Your bond on this case is $2,500. Thank you. That's all we need. Bonds are stayed. Yeah. Oh, okay. Gotcha. Okay. Next case I have is Amanda Street.
It's mental health, Your Honor.
Mental health. I feel kind of like joining her right now. Okay, Nicholas Todd?
Yes, sir.
Is that your name, sir?
Yes, sir.
All right, sir, you have been arrested for failure to appear on a possession of cocaine. Apparently that's a new word. Possession of cocaine and possession of drug paraphernalia. Your bond in those matters is $1,000 on the possession charge and $500 on the other charge. Do you have, is the public?
RCC represents him.
Oh, okay, so we don't need to do anything about that. Thank you, sir.
Thank you.
Lonnie Williams?
Yes, sir.
All right, Mr. Williams, you have been arrested on the charges of burglary of an occupied dwelling, possession of methamphetamine, possession of cannabis, providing false ID to law enforcement, and resisting officer without violence. I do not find probable cause on the burglary part. Yes, in this case, the basis of the burglary was him jumping a fence during a pursuit by law enforcement. I believe that there is case law that says that entering a dwelling for the purpose of evading capture isn't a burglary. So I do not find probable cause, and I don't feel there's a need to extend that. So as to count 1, you'll be ROR'd. Bond on count 2 is $2,000. Count 3 is $1,000. Count 4 is $1,000, and count 5 is $1,000, and those will be stayed.
That's it.
All right?
Thank you.
You bet. All right. Next file.
Does he?
Oh, I'm sorry. Wait, hold on a minute. You know what? I think I missed one. Just a minute. Hold on. Oh, keep him here for just a second. Was there another one? Oh, there was. Yes, Mr. Williams. I'm sorry. There's a second case. It snuck in here. You were also arrested for driving while license suspended. I do find probable cause as to that as well, and the public defender will be appointed on that case as also, and your bond on that case is $1,000. All right, thank you, sir. Thanks for catching that. This. Oh, okay. Oh, okay, I want to take those. Okay. Your name, sir?
Burley Bennett.
All right, Mr. Bennett, you have been arrested for, let's see, it says contempt of court, violation of injunction against stalking, and, okay, it has the statute number. So you're arrested for violating a injunction against stalking. I do find probable cause for that violation. Your bond right now is $250. No, I don't want to ask you any questions. Never mind. Would you like the public defender appointed?
Yes, sir.
Okay. The court will appoint the Office of the Public Defender to represent you, and your bond is $250. All right, sir? And I was about to say, didn't I enter that injunction? But then I thought, no, I better not say that. Okay. Ty McLaughlin?
Yes.
Did I get that right?
Yes.
Okay, you were arrested on a charge of driving while license suspended or revoked. I do find probable cause based on the affidavit. Your bond is set at $500. You've asked for appointment of the public defender. The public defender will be appointed to represent you.
Okay.
All right? Thank you, sir.
Thank you.
He does meet PTR criteria. Would you rather have PTR where you would get out now, but you got to check in on a regular basis, or would you rather put up the money?
I'd rather get out now.
You got the money? Or you want to get out now?
Yeah.
Okay, PTR then.
I don't care about PTR. I'm drug free. Yeah.
Good, PTR. All right.
Now, if I have a purge on child support, we'll have to wait until I pay that, right?
Yeah.
All right. So once I go to court Tuesday.
Once you purge the child support, once that's lifted, then you can get released on PTR in this case.
Think that's a wise decision to do the PTR?
It's up to you.
Either way, it doesn't matter. You still can't get out till you pay your child support.
All right, that's fine.
All right,
PTR.
take care.
Thank you.
All right. This is Shimas Murad.
Yes, sir.
Did I pronounce that correctly?
Murad Shimis.
Okay. Oh, so you're Murad Shimis. I'm sorry.
Yes.
You have been charged in this case with driving under the influence. I do find probable cause for that offense. You have, let's see, did you ask? Yeah. Would you like to have the public defender appointed to represent you?
I would like to hire a lawyer.
Right. Well, let's get to another point. You have a pending case, 2019 MM 3053, that you received a notice to appear on, which is possession of cannabis, possession of drug paraphernalia. Do you have a lawyer in that case?
The PD represents him in that case.
PD? All right, public defender is appointed in the new case as well. I'm not going to take any action on the old case. So your bond is $500 on the DUI case.
I have a question.
What's that?
If I pay the bond, does that mean I get to go out today?
Yes, if you put up the bond, you get to leave jail today and then come back at another time.
And will I be receiving mail to tell me the date and time?
Yes. As long as you got a good address and you keep us informed of your address, yeah. All
Thank
right?
you.
Okay, Jean-Paul Anglero Alvarez. You get that right?
Yes.
All right, so you were charged with a crime of trespass on property after warning. I do find probable cause for that case. Would you like to have the public defender appointed to represent you at this hearing? All right, public defender's appointed temporarily. Your bond is set at $500. All right? All right, thank you very much. Bond is stayed. All right, sir, Victor Brown. Are you Mr. Brown?
Yes, I am.
All right, sir. You have been arrested for the charge of camping. And you actually had you allegedly actually had a sleeping bag, which is more, which is better than what I usually see, which is just on a bench. I do find probable cause for that violation. If you would like to resolve this today, would you like the public defender to be appointed to represent you in this hearing?
Yes.
All right, public defender is appointed.
It sounds like he wants to fight. I wouldn't feel comfortable entering a plea.
I'm sorry, it sounds like what?
It sounds like he wants to fight it. I would not feel
No problem.
comfortable entering a plea.
No problem. So
I
your
would-
bond, go ahead.
I was gonna say, I'd ask for him to release on his own recognizance. It's the state's bond policy to advocate for ROR in nonviolent misdemeanors and city ordinances.
You should just record that and play it. Save you on your vocal
I mean, they
cords.
may want to make a big,
has no
like,
objection.
PR statement about it.
I've noticed. Go ahead.
State has no objection to an ROR.
ROR on the agreement of the state it is. You're gonna have to tell them someplace to send your mail if you want to fight it, because otherwise we won't be able to get in touch with you.
There's a P.O. box that I use, Your Honor.
Tell the clerk.
Okay,
P.O. Box 990, Orlando, Florida 32802.
you got that? State, you might wanna write that down. P.O. Box 990,
Orlando, Florida
Orlando, Florida,
32802.
32802. So tell the city that's where they can send the notices.
Thank you.
Thank you. Okay, LaToya Gullins, is that your name?
Yes.
All right, you've been charged with petty theft as a first, in the second degree as a first offense. I do find probable cause for that offense. Would you like to have the public defender appointed?
Yes, sir.
All right, public defender is appointed to represent you. Your bond is set at $500. And thank you very much. Bonds will be stayed. Let's see. Mr. Is it Hamden? All right, sir. You've been arrested for the charge of petty theft, $100 or more. I do find probable cause for that offense. Would you like to have the public defender appointed to represent you? All right, you do qualify, so the public defender is appointed. Your bond is set at $500. All right, sir. All right, sir, are you Mr. Haynes?
Yes, sir.
Mr. Haynes, you are charged with possession of cannabis under 20 grams, right? Okay. Under 20 grams. I do find probable cause to believe, to find that you have violated that law. Your bond, would you like the public defender appointed?
Yeah, but yes, sir.
All right, public defender is appointed. You do qualify, and your bond is $250.
Thanks.
All right, sir. Thank you. Okay, Richard Howell.
Mental health, Your Honor.
Mental health, all right. Mr. Hauser, mental health, all right. Brandy Laster.
Yes, sir.
Laster, you have been charged with the offense of trespass on property after warning. I do find probable cause exists that you committed that offense. You've applied for the public defender, so the public defender will be appointed to represent you in this matter. Your bond on that charge is set at $500.
She wants to know if she can resolve her case today.
State?
The state would be willing to do a credit time served.
Okay? Okay, well, don't get too happy because I haven't sentenced you yet.
Yes, sir.
Now, 7-Eleven does not want you there.
Yes, sir.
You understand?
Yes, sir.
But you keep going back. Right?
Yes, sir.
So what's it going to take to keep you from going back? Other than having you in jail.
Maybe I should work harder on a different business venture that I have.
Work hard on what?
I should put more time and energy on my new business venture that I'm working on.
You should, but whatever business venture you're involved in, you can't do it at 7-Eleven.
Yes, sir.
Just stop going there,
Yes, sir.
okay? All right. You'll be sentenced to credit for time served.
Thank you, sir.
I hope I don't see you back again, because I don't think I'd do that again, because just a lot of resources are spent just trying to get you to stop going to 7-Eleven. Is
Yes,
it the
sir.
big gulp? Is that what draws you?
It's the big gulp.
That's what draws me, is the big gulp.
It's a big gulp.
Okay, well, no more big gulps for you.
Yes, sir.
All right, Kevin Mitchell.
Refuse, Your Honor.
Refused. Well, I'm offended. I spend all this time, I get dressed up, and then they won't come see me. Are you Mr. Sparaga?
Yes, sir.
Yes, sir. You have been charged with trespass in a structure or conveyance. I do find probable cause. Well, wait a minute now. This isn't charged as trespass after warning. So,
It would be that, the elements of that are like, someone told you to leave and you refused to leave, like right there on the spot.
okay. All right, I find probable cause. Would you like the public defender appointed?
Yes, sir.
Public defender is appointed to represent you. Your bond is set at $500. There you go. All right, sir. Philip Williams. Sir, you are charged with, arrested for trespass on property after warning. I do find probable cause that you committed that offense. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right, I don't have an affidavit of insolvency, pardon me, but we'll represent the we'll appoint the public defender to represent you for purposes of this hearing. Your bond is presently set at $1,000. Okay?
I want to ask him, like, can I be OR? I'm on vacation in my family.
He wants to know if you'll either reduce his bond or release him on his own recognizance. It looks like he has a few out-of-state misdemeanors, convictions.
State?
The state would object to ROR, but not necessarily to lowering the bond.
All right. Where are you going to go if you get out?
I stayed. My family is on vacation, and we was at this place, and I was standing outside. Police come up and
Don't.
Yeah, don't tell me about the crime. I just want to know where you live.
in a place called Georgia, state of Georgia.
Georgia? I never heard of Georgia. No, I've heard of Georgia. You're from Fairburn?
Yes, sir.
Were you down here on vacation?
Yes, sir.
We're not very hospitable, are we?
Well, I ain't got no problem. I just want to
I'm sorry.
Go
I'm
home.
just kidding.
Please.
So I'm going to release you ROR on your own recognizance, okay?
Yes, sir.
So if you go back to Georgia, did we get an actual address from you?
Yes, sir.
No, we don't have an actual address.
Yes, sir.
What? I'm sorry, what? He'll get it? Okay. So you're going to get out of jail, all right? If you go back to Georgia,
Yes, sir.
then they'll send you a notice for when you're supposed to come back. Now, if you don't come back, they may not do anything. Or they may issue a warrant to have you arrested if you come back to Florida.
Just go to all your court dates.
You'll get all your court dates. All right?
I'll
Okay.
show up to court.
Have a good day. Have a good day. Normal, okay. Are you Mr. Graham?
Yes, sir.
David Alexander Graham, okay. Let's see, what are you here? Oh, because you refused to join us the other day. You have been arrested on a charge of possession of drug paraphernalia. Court finds probable cause that you committed those crimes, which you requested the appointment of the public defender. You do qualify, so the public defender will be appointed, and your bonds on those offenses are $2,000 on count 1 and $100 on count 2. Understand that?
Yes, sir.
All right. Good luck.
Your Honor, first appearance detainer. Mr. Graham.
Oh.
No
Oh,
information.
is that this one? Oh, see, I always get confused. That's a different, wait, hold on. What are you talking about? So what?
Yeah, you just-
Oh, okay, I got you. So that's a copy of what's usually yellow. Ah, see, you messed me up with the color. All right, so you are out on bond on 2019 MM 3277. Counsel, anybody want to say anything?
Yes, please. No information's been filed in that case, and it's been over 33 days.
State would ask that the bond be revoked.
Nope, no action. All right, Donald Petty.
Yes, sir.
That's right, we
This-
met yesterday.
This was reset because the state was supposed to provide probable cause for the burglary.
Right.
I did not receive any supplement for the burglary.
All right, then the court will ROR as to count 1, burglary of a dwelling, and the $150 bond will remain on trespass after warning. I believe I appointed the public defender yesterday. If I didn't, I do now. And good luck to you, sir.
Yes, sir. I didn't really.
Okay, Dante Rucker,
It's medical, Your Honor.
medical. All
We
right,
just reset that for 24 hours after he's been released from the hospital.
all right. Well, that was wise of me. All right, Ms., are you Rasha Russell? Okay, Ms. Russell, you have been arrested for possession of methamphetamine with intent and possession of methamphetamine. The court finds probable cause as to both offenses. You have filled out an application to have the public defender appointed, so the public defender will be appointed. Your bond on the possession of methamphetamine is $15,000. Your bond on count 2 is $100.
May I be heard?
Yes, you may.
Would the court consider reducing the bond to $3,000 or $2,500? She only has one misdemeanor conviction.
State?
Your Honor, the state would have no objection to reducing count 1, though the state would request at least $5,000. And I think the bond on count 2 is $150?
Right, it's $150.
Okay.
Yeah.
So I just didn't know if that was.
State will reduce bond on count 1 to $5,000
And 100 on count 2.
and $150 on count 2. All right. Carlos Torres Cardona,
He's medical, Your Honor.
medical. All right. Let's see. Bishop Ferris, or Ferris Bishop?
Bishop Ferris.
Bishop Ferris, okay. You have been charged with grand theft, third degree of a motor vehicle in one case. Court has examined the arrest affidavit and finds probable cause in that case. You also, would you like the public defender appointed in the new case?
Excuse me?
Well, you filled out an application for a public defender, so I'm going to appoint the public defender, In the new case, to represent you, your bond in that case is $2,500. On the second matter is a violation of probation based upon the facts underlying the theft case, saying you violated your probation on, I believe it was another grand theft case. The court finds probable cause in that matter, and the bond in that matter will be set at none until you appear before a judge, and public defender is appointed on both cases. Sir? There you are. Eugenio Foronda?
Yes, Your Honor.
Okay. You have been arrested on a violation of probation based upon, let me see, make sure this is a warrant. Yeah, this is a warrant for violation of probation. The bond that has been set on that is no bond, so you will remain in jail until you see the judge that issued the warrant. Would you like the public defender appointed to represent you in the case?
Yes, Your Honor.
Public defender is appointed, you do qualify. Thank you, sir. Okay, Diamond Weary?
Refuse, Your Honor.
Refused? Okay. All right. Raymond Butler?
Yes, Your Honor.
Mr. Butler, you are here on a charge of open container. I do find probable cause for that offense. Would you like to have the public defender appointed to represent you?
Yes, sir.
Public defender will be appointed. Your bond is $250. All right?
Okay,
That's it.
that's it. I didn't get a chance to,
You want to plea it? Is that
yeah,
okay?
I'd like to plea
Oh.
if I have an
Coming on
option.
back.
If we can resolve it today, I would like to.
Well, state.
Just a moment.
They'd still reserve that devil brew.
The state would be willing to do a credit time served offer.
All right? So state says if you want to plea, they'll just give you credit for time served, and you'll be adjudicated guilty, and you'll be out of here.
Yes, sir?
All right?
No, ma'am. Yes,
Okay, do you understand all the rights that you're waiving on that piece of paper?
yes, sir.
Okay? All right? And do you believe you are in fact guilty of open container?
Yeah,
Okay, you were drinking the Steel Reserve out in the open in the city of Orlando. You son of a...
I should have known better.
Should have known better, that's right. I was drinking, I was drinking a beer at a restaurant in Baldwin Park yesterday. I was waiting for my family to get there, and I started to walk outside with the beer, and I was like, well, I don't know if I can do that. So I didn't.
Thank you, Your Honor.
You bet. So you'll be sentenced to 2 days? 2 days time served? 1 day, 2 days? 2 days credit for time served. Go forth and sin no more. Thank you.
Thank you.
Close to the end, I'm getting biblical. All right, Deandra Jackson.
Yes.
Okay, you have been arrested for disorderly conduct, for smashing and don't tell me whether he did or not, smashing a bottle on the road in a crowd of people, apparently, supposedly, allegedly, I should say. Would you like to have the public defender appointed to represent you in that case?
Yes.
All right. Public defender will be appointed to represent you. I do find probable cause on that case, and your bond is set at $250.
We'd like to resolve this case if possible.
State?
Is it 2 days?
Pardon?
Does he have 2 days credit, or?
2 days credit time, 2 days?
The state would do a credit time served offer.
So you want to accept that plea offer?
I didn't hear.
I'm sorry, I couldn't hear you.
I didn't hear you. I didn't hear.
Okay, the plea offer,
All right. Yes. Yes. Yes.
okay. So do you understand the rights you're waiving by signing that form?
Yes, sir.
All right. So the court's going to accept the plea of guilty. I find a factual basis from the arrest affidavit, and I sentence you to time served, which is 2 days in the Orange County Jail.
Thank you.
All right, sir. Go forth and sin no more. Sent everybody, please. Except for those really bad guys. All right, sir. You are charged in this case. Oh, I'm sorry, sir. Are you Joseph Johnson?
Yes, sir.
And you're charged in this case with disorderly conduct. Let's see, this was, you're charged with disorderly conduct for soliciting money from cars and walking up and accepting money, which I am educated. I didn't know that was disorderly conduct, but apparently it is in Orlando. I do find probable cause in that case. Would you like the public defender appointed?
Yes, sir.
All right, we'll appoint the public defender to represent you, and your bond is set at $250.
Mr. Johnson resolve his case. His indicated he would.
State?
State would offer a credit time served.
You want to do that?
You want to take credit?
Yes, sir.
All right. If you'll sign the plea form, understand all the rights on there that you're giving up in this case,
Yes, sir.
except the right to counsel, because you got a good one.
We gotta wait.
Hold on, don't leave yet. I haven't sentenced you yet.
Sorry. Everything's going so fast. Sir.
I know you're eager to get out. I don't believe it. I am too, by the way.
God bless you. Thank you.
You betcha. I hereby accept your plea and sentence you to 2 days time in Orange County Jail, time served. Go forth and sin no more.
Thank you.
Thank you. Good luck to you. All right, Sajad, or sorry, sir, what is your name? What? Ah. Could you tell me your name, sir?
Sajad Riaz.
All right, sir. You have been charged with the offense of open container of alcoholic beverages within the city limits. I do find probable cause for that offense. Would you like the public defender appointed?
Yes, because I'm guilty with the explanation because
Okay.
I came from New York and they open container.
Okay. I'm appointing the public defender to represent you. Since you just confessed, do you want to resolve this today, State?
Yes.
State would be fine with credit time served.
All right. So if you want to sign that plea form, you're waiving all your rights to trial, et cetera. It's all listed there. They're very important. If you want to accept the plea, then sign that form, and you'll be sentenced to 2 days credit for time served.
Will you give the probation and immigration warning? Because I don't know if you can hear me.
Oh, yes. Okay. So if you are not a U.S. citizen, understand that a conviction for any crime may result in deportation. So if that's a concern to you, you need to keep that in mind. I don't know whether they deport people for open container violations, but in these days, I don't know. So if you don't have to tell me one way or the other, but if you're not a U.S. citizen, this could result in deportation.
No, I'm U.S. citizen.
Excellent. And you have no problems.
Okay.
If you want to do this, sign the plea form, and we'll resolve the case, and you can get out today.
Okay.
All right? All right, sir, so.
Thank you.
I accept your plea. You're sentenced to 2 days, time served in the Orange County Jail, and now you know that you can't do that here.
Okay.
All
Thank
right?
you.
Take care of yourself.
Have a good day. Thank you.
Sandra Santiago. Santiago, you are charged in, you've been arrested for the offense of camping in violation of Orlando City Ordinance. I do find probable cause for that offense. You've asked the public defender to be appointed. You qualify, so I appoint a public defender to represent you. Your bond in this matter is $250.
It's the state's a non-monetary bond policy to advocate for ROR in charges such as this.
State has no objection to ROR.
Oh, no, you're supposed to advocate for it. You're supposed to, like, ask for it. Did you
That's
get
what the bond policy says.
That's fine. Would she prefer us to resolve this today? Okay. State?
Credit time served is fine.
All right. So, ma'am, what they're saying is that if you want to enter a plea of guilty today, that you will be sentenced to credit for time served, 2 days, and you will get out. All right? You understand the rights you're waiving on that form? You need to answer out loud for me. You need to say, yeah. Do you speak English? You, okay, good. Well, read and sign that paper.
No, not there.
All right. I accept your plea as free and voluntarily entered. You will, I find you guilty and you're sentenced to 2 days with credit for time served. Just remember, you can't sleep out in the open in the city of Orlando, okay? You gotta go, I guess, out in the county. I don't know if they allow it out there either, but hopefully. Good luck to you.
Thank you.
See, are you Mr. Taylor?
Yes, sir.
All right. You're my favorite defendant of the day. You know why?
Why?
You're the last.
Yes. I know. I've never been last before.
Sorry you had to wait so long.
That's all right.
You've been charged with the crime of disorderly conduct in Orlando, again, for approaching vehicles at lights, soliciting and accepting money. I do find probable cause for this offense. Would you like to have the public defender appointed to represent you?
No, I would like to resolve it.
You what? Resolve it?
Yeah, I want to
Okay.
resolve it.
State?
Credit time served offer.
All right, state's offered you to resolve the case by credit for time served.
Thank you.
You have a plea form in front of you where you're waiving some valuable rights. I'll make sure you understand what you're waiving, and you can sign it.
Yes, ma'am. Yes, sir.
Did you commit the offense of disorderly conduct by soliciting money from cars that were stopped at a red light?
Well, it wasn't soliciting money. It was just soliciting for anything, like
for anything.
food,
Okay.
clothes,
Yeah.
and money.
Can't.
But money wasn't on the sign.
Somebody wanted to give you a car, you'd have been fine.
I'll take it.
I'll take it. Give you an Xbox or a chair or who knows what. Anyway, all right, I based on your free and voluntary plea, I do find there's a factual basis in the arrest affidavit, and I find you guilty and sentence you to 2 days credit for time served. Go forth and sin no more.
Yes. Thank you.
Have a lovely day.
Hey, can I ask you a question?
Sure.
You look very familiar. You look like I've seen you before on TV somewhere.
Yeah.
Gordon?
Oh, you.
A few years ago, yeah.
Oh my God! Nice meeting you.
Nice to meet
I
you
wish I
too.
could get your autograph. Oh, I have it, right?
You have it on there somewhere. That was a great end to the day, wasn't it?
Yeah.
All right, court will be adjourned.